Violence.
Page wise mentioning, page number 1, item 1 to 12, page number 2, item 30 to 24.
Item number 19, Item number 119, my lord, your lordship may take up this matter after 2 weeks. Compromise talks are going on, my lord.
Sir,
19, my lord. 2 weeks, my lord. 19, my lord. CRP 776 of 2022. I have informed other side also, my lord.
26 and post after 3 weeks. Item 19.
Obliged.
Number 3, item 25 to 37. Page number 4, item 38 to 50.
Item 48, needed some time. Does council's direction.
Okay, can you go outside?
Discuss as a compromise.
Okay, wait, sir. Then I'll pass orders. 44. Okay, council has 6 and post after 4 weeks.
Page number 5, item 51 to 63. Page number 6, item 64 to 77. Page number 7.
Mr. Lordship's item number 68, my lord, I am appearing for the respondent in this matter. Informed to the other side, my lord, the Lordship may have this matter after 2 weeks, my lord.
Informed, sir. Okay, council.
I informed to the other side, my lord.
6 and post after 3 weeks.
Page number 7, item 78 to 91.
Your Lordship, item number 83 and 84, and with the petitioner seeking to be studied.
2006 and post after 4 weeks. Item 83, 84 and 85.
Item number 81.
81.
Yes.
Ramada. Yes, sir.
3 weeks time. Because it doesn't.
Council constitution post after 4 weeks. Item 81.
Page number 8, item 92 to 95.
Yes.
Item number 145, my lord. The appellants of the 4 appellants, 3 appellants died, my lord. I did some reason it was returned, my lord. I submitted and take steps.
No maximum for the then this class. Wait, sir.
The Lordship.
Yes.
Item number 1.
No, sir. No maximum. Item. Yes, sir.
CRP 124 of 22. To interim order all the
Vacant petition.
Yes, my lord. CRP, my lord, can be disposed of.
Vacant petition filed.
We can finally cut, my lord.
Not filed as vacant petition. For 2 weeks. 2 weeks after 2 weeks. No, sir. I am not addressing you. That is one matter. Yes, sir.
17 of 21, you are.
After 1 week.
Extension of increment. Not extend only.
Come tomorrow, after tomorrow, sir.
With the vacation will was not.
CRP number?
CRP number 1614 of 2020.
After tomorrow. So, this is going to be after tomorrow, sir.
116 of 2022. Not evidence.
Not tomorrow. Not tomorrow. After 1 week. After 1 week.
CRP 1692/2023, my lord. Trial is proceeding without the superior holder, my lord. Identity petition was dismissed, sir. Last time the notice of the audit, we have filed in the court service in the matter. It will be taken up for hearing.
After 2 weeks. CM of 22, I have no problem. CMA. CMA, CMA, madam. CMA, okay. After 2 weeks.
173/04. But this is for it. Restoration application is only.
Come, sir. It will come.
Already have permitted me 2 times, but the registry is not listed in my.
Don't know, it will come, sir. It will come. Yes, madam, what do you want? No, madam, sorry. I will not
My
permit.
lord, CMA number.
Yes.
It has been abated.
Abated, record is there.
Yes.
Item number? 184, constable, upload permit, sir. Full upload. Expect. 184, madam. Whose name? You are mentioning?
Jagannath.
Okay, you are not.
My lord,
Okay.
CMA number.
There, so, those are not current. Those there, debated. This is not debated. Yes,
My lord, CMA number 176/2020, my lord. Trial for petition the party to get in interim order. Interim order, my lord.
specialty models, post after 1 week. Oh, yes.
3, right?
Then file petition, sir. Yes, sir. Then file petition. Call this man.
Calling the list item number 1. T. Mahinder Rao K. Landmark.
Yes, sir.
Okay, what is this? Okay, so, get it. Price down.
Yes, madam. I permitted that to withdraw the 50% amount by the, that's fine. Yes. I have an order. I have to. Okay. You file claim is yes or order to the. What is public file order? File order 3 permitted to. Which the 2% of the amount deposited by the. Respondent apply the account of DC number 1/2021. For financial issue. Entities admit post for hearing for entity after 8 weeks. What is to the respondent number 4. You go to the letter, this is letter 4. After the current 4 below.
Item number 2. Srinivas Murthy Children.
Yes, sir.
There is just tomorrow is motion. And it was not a party.
Sir, notice has to go, sir.
In this case,
You have filed a leave petition.
yes, sir.
Notice has to go.
Tomorrow it will. Tomorrow, because it is.
Yes, sir, but tomorrow also,
We have to argue the matter.
you file a leave petition notice has to go, sir.
Certainly. Tomorrow, only.
I'll put out 1 week. Post for the season, post for.
Motion list.
You will leave, sir, after 1 week.
Ashika Kumar.
Yes.
Delay is not 64 days.
I have an order, I have to, no suspense, post after 8 weeks, I have 3. Stay 50%. Sir. No, sir, 8 weeks. If there are days, you don't. Huh? You have to engage council also. Post after 8 weeks. For sure, deposit amount, sir, within 6 weeks.
4. Ajay Kumar participating.
Yes, I have an order. In case it meets notice, post after 8 weeks. Cause for the appellant, HIGHCOURT for the service.
Item number 5, Hanna Reddy Soma, G.
Yes,
Narendra
ma'am.
Reddy.
The KYC petition filed by the other side, I will permit them to withdraw the amounts. Anyone ordered? I had to stay. Then you the number 78 of the. Phone की आता फाइल 15 chief HSC recommend attention to plan provided to deposit $50,000 amount within 6 million and depositing the amounts. The respondent, the public respondent number. Respondent 124. So being made a minor, mention the minor. Respondent number 3.
In the time of filing 70 days.
Okay, they are mentioned as a minor. So, respondent 124 permitted to withdraw the amount. For their question. Okay. Yes. Main case admit. Also finding of 8 weeks.
Item number 6, Hanna Reddy Soma.
Yeah, one, the insurance agreement, I want to discuss it as a.
Another, they have to. Yes, but when the week notice, post of 8 weeks.
Item number 70, 7 to 1.
I will order in case admit notice post of 8 weeks, cost for the appellant, HIGHCOURT for service.
Item number 18, Ajay Kumar.
I have an order, I have to process transport of 8 weeks. I have 3 state. Brother, 6 weeks. Post of 8 weeks.
Item number 9, A. Yadav Reddy.
Lord, I'm appealing. My lord, the present appellants are the plaintiffs filed suit for injunction, my lord, in respect of land advising 2 acres 31 Gunta, A class 4 village mandal, Sangara district. Initially, suit was decreed, my lord. Unsuccessful defendants filed first appeal, my lord. The appeal was allowed by the Honorable Court, my lord. Last judgment. Sorry, my lord.
Suit for injunction.
Suit for injunction, my lord. Initially, trial court was decreed, my lord. Upload reversing judgment, my lord.
On what grounds?
Last may kindly see 16 to substantial of question of law, my lord. 16 ground number 16 to 22, my lord.
Sir, I want to see the appellate court findings, sir.
Yes, my lord. Yes, my lord. My lord, in the very strange case, my lord, they have admitted the possession, my lord. Defendants admitted possession, and they have filed suit for declaration and recovery of possession against these plaintiffs, my lord. A very strange case, my lord. Your lordship may kindly see the now 40 issue number page number 15, my lord. Issue.
Yes, sir.
Plaintiffs and defendants have been claiming rights over the property by virtue of the purchase of the same by them respectively. In a suit for perpetual injunction, the position of the plaintiff has on the date of filing of the suit to be proved by the plaintiff. The question of title of plaintiff can be go into incidentally to prove about the date and source of the physical possession of the property by the plaintiff. It is also settled law that the plaintiff has to prove on so. As per the case of the plaintiff, exhibit A is the registered sale deed, my lord. They have purchased under unregistered sale deed, my lord. The plaintiff, the defendants purchased under unregistered sale deed. Subsequently, it is regularized. Final proceeding has not been issued, my lord, till today. 13C is not issued, my lord. Only 13B is issued. 13C is not issued, my lord. Your relevant paragraph, my lord, your lordship may kindly see the page number 8, my lord.
Page number 8.
My lord.
8 or 18, sir?
18, my lord, 18B.
Yes, sir.
The collector sent a report that until survey is done, it is not possible to mutate the revenue records in favor of the defendants, my lord. They are claiming under unregistered sale. It was mentioned in the letter. The collector dated 12/6 said the sugarcane crop was raised by the plaintiff and her husband. He admitted about filing of suit 103. This is the suit filed by the defendants, my lord, for suit for declaration and recovery of possession, my lord, above the family court Sangareddy against the plaintiff and their family members. Tahsildar and collector for the declaration of recovery of possession and restitution. The entire land, and it was dismissed. Suit was dismissed by the defendants, my lord. Further, he filed OS number 41 of 2015. So and so, senior court. Only finding of the court is that the plaintiff did not file those documents before the trial court. Those proceedings were not, those suit proceedings papers were not filed before the trial court.
Moreover, the proceedings are different survey number, same survey number, sir.
And different, so many number of survey numbers are there, my lord. 113, including the suit survey number, my lord. Suits are, they are claiming some other extent, my lord. We are claiming only 2 acre 31 gunta in this suit, my lord. It's a large extent, my lord. It's a large extent. We are claiming this appellants claiming only 2 acres 34 guntas, my lord.
Para number, page number 23, para 31. This is the finding of appellate court.
Plaintiff did not produce any authenticated documents of legal proceedings of, if any, which title and possession of the plaintiff over the suit land have been confirmed before the trial. The respondent in this appeal have raised doubt in respect of the admissibility of document under Exhibit B13, 14, which are said to be 13A, 13B. 13B, 13A are 13C is the conclusive proof, my lord. 13B, 13C is the title document in this matter. Moreover, the plaintiff filed registered document, my lord. He is claiming under Exhibit A8, my lord. A8 is the registered document, my lord. He has filed Pahanis, subsequent Pahanis after purchase of that property. He has filed Pahanis, my lord. Your lordship may kindly see the page number 46, my lord. If documents were marked before the trial court, my lord, your lordship may kindly see 46 page.
2006, why from 2006? So filed 2002, 2004, 2003.
My lord. Exhibit 8 is the original sale, registered sale deed, my lord. He is claiming unregistered sale deed, my lord. We have filed registered sale deed, my lord.
Yes, sir.
Moreover, defendant himself admitted our position, plaintiff's position over land, my lord.
Show me relevant para.
My lord.
Show me relevant para. Where is the admission?
Yes, my lord. Yes. My lord, page number 14, my lord. 13, last paragraph, it is further observed that DW1 filed OS number 103 of 13, Sangareddy, for court declaration, recovery of possession, and rectification of record, and it was dismissed. And in that suit, he admitted that the plaintiff is in possession of the suit.
Yes, sir. Show me the question of law.
Well, Lordship, may kindly see 16 to 22, my lord, round number 16 to 22, my lord, substantial question of law. Whether the judgment of the lower appellate court is sustainable in law in the absence of clear and categorical finding recorded by the lower court in reversing the findings recorded by the trial court, which has been rendered strictly in accordance with the permissible evidence on record. Whether a right and title conferred under the register sale is standing in the name of first appellant initially, as contained in Exhibit A8, the subsequent documents issued in accordance with the ROR Act contained in Exhibit A3 to A6 can be taken away in the absence of in the absence of cogent evidence on record in rebuttal by the respondent defendant. Thus, such course not amount to perversity of law in law. Whether the appellate court is justified in recording a finding in respect of the pivotal issue as the identify of the property, which is neither part of pleading by the respondent defendants or oral document evidence on record. Justified in placing reliance on documentary evidence, more particularly the simple sale transaction and subsequent issuance of 13B of the ROR Act. In the absence of production of order or proceeding granting 13B of the ROR Act, does such course not amount to non-appreciation of the relevant law governing the subject? Whether the judgment of the lower appellate court in ignoring the provision of under Section 58 of Evidence Act to the effect that admitted facts need not be proved in substantiable in law, as the lower appellate court lost its sight to place reliance on the admitted fact by the defendant during the course of cross-examination to the effect that the appellate here in possession.
Catherine, I'll take note of 17, 20, 21. Three issues. Consideration. 17,
My lord,
21.
my lord.
3. Not all. Consideration of the second appeal. Okay. Here comes for petition. The following questions.
My lord, defendants are influential person, my lord, unless it is suspended, they are highly
Pending your rejection order in your favor.
No, my lord, suit was decreed, my lord. Thereafter, they have been in position. Appellate court did not suspend the judgment of the trial court, my lord.
Any intimacy in favor of the respondents pending appeal?
Initially, there was interim order. Subsequently, it is vacated by my lord. Highly influential person, my lord. They are paid.
1 minute, sir. Vacated by the appellate court, sir. No, pending appeal, intimacy in their favor.
Sorry, my lord, I am having not entire record, that is.
Then I will post after 1 week.
But no, appellate court did not suspend the order of the trial court, my lord. There was no suspension at all.
No, verify, sir. Verify. Post after 1 week. Post after 1 week, no? That is better. Pass orders intimacy after 1 week. I'll get it confirmed.
Your lordship, me.
After 1 week, sir. I will pass orders after 1 week, sir.
Much obliged.
Post after 1 week.
Item number 10. G answer.
Yes, sir. How many days, sir? Notice has to take a notice, sir.
The corona has come and also unfortunately 2 deaths happened. I also checked at parent number.
2 days of
Already in the family of the applicant. That's why that I'm get the papers. That's why delay happened. 2 and I have 4 also I think. Two unfortunate days. As happened that attendance death of two family members. The family did and there is no delay in the second appeal. Later statement.
So now who is legalized of the defined number? Apply number 2 and 4. Sir, mentioned cost, see the cost item. Apply number 2 died, teacher. Apply number 4, agriculture died. Then you have to include petition for include apply number. No, sir. How can you file petition without including the appliance number 2 and 4 of the legal of the number 2 and 4? No, sir, they are independent. They are 38 years of the appellant on this. What is the date? Of 2019. Sir, 2013 is 38 years, sir. It's separate family. Page number 36, see the page number 36. Age of the fourth appellant. Namik Karam Kumar. Sorry. What is it? Sorry. Actually, Kiran Kumar, sir, you mentioned as a Kiran. Yes, sir, run the type. Past and also. His age is at the time of 2013, age is 38 years. Now, 48 years. Separate families there, sir. Not they are not applied for LRs. Not only, sir. Then we have to file a LR petition, sir. Along with the petition, post office 6 and post office 2 weeks.
Item number 11, A. Jagan.
Please. Yes, sir.
Also finish also in the OP 286 of the Constitution on the file of the family court rendered to Dima. But if the petitioner filed a DVC.
Only DVC. No 488 MC.
But DVC.
Pharmacist, okay, she's already pharmacist working.
He is not doctor. So these are the doctor. Because Irmal to Rangaradi is near 250 kilometers. After receiving a DVC, he filed a divorce OP.
Production, post of right weeks, post of petition, take out for service. This will share OP number 287/2023 on the file of family court, 4th additional district and session judge, Rangaradi Kokatpalli. I think FC OP, sir, or OP, sir, only.
Christian, he was Christian.
Okay, OP. HM, okay, OP.
Item
It
number
was
15.
Yes, sir.
Councillor, the data should be filed as respondent. Criminal proceedings and the 498 days pending. EPA holder,
Okay. If you want to file the FC findings. Resolution, post of right weeks, post of petition, take out for service respondents. GP holder. The take on respond only. To GP holder only. Ayama, FC OP number, on the file of Judge Family Court at Karnataka. Yes.
Item number 13, agent. Item number 14, Ashok Kumar Agarwal.
The number CRP is also 350 from 2021. Valuable listed.
What is the CRP, sir?
Again, the dismissal of the EP information petition. There are 2 EPs left. There is the order in the partition suit, which was decreed. Thereafter, EP is filed for allotment of shares and attachment of the property of.
1 minute, sir. But CMA would tell them. 1 minute, sir. The CMA is
Last time also same mistake of last time and on 23rd, on 14th June also same mistake was happened. In place of CRP, CMA was listed.
No. Target source CRP 25. Bundle source.
Yes, sir.
CMA.
Same thing happened last year. You have to 355 to 21 and 355 21. And we got to listed next week.
limit of CRP ఏం ప్రాబ్లం ఉంటుంది ఇక్కడ వాళ్ళు సీఎం సిఆర్పి లాస్ట్ కోర్ట్ మాస్టర్ దాంతో అన్ని సిఆర్సీ అనుకో నెక్స్ట్ మంత్ ఈజ్ హాస్పిటల్ సర్వీస్ సార్ that is not CRP number class member. CRP number 354 sir 354 of 2021 post spread around CRP number 354 of 2021 after 2 weeks sir. Already here sir, the call is 355. Present case 355. Definitely the last CRP number 355.
Item number 15 to something. G. Mansudan Reddy.
Two docket CRP. At the Mundu docket CMA. Back page on the sorry. CMA one from the CRP. Yes sir.
The three CRPs, same suit suit is partition the sword creative right the last file of petition to set aside the amendment and also the last petition. Clear petition is 7 days. On the ground that the appellant, the petitioner number 1, she is a GPA holder. She is representing the matter to mother. On that ground, the document taken of CRC 300. Delay petition is with the other ideas also.
Almost 200 days, almost delay, 207 days delay.
The honorable apex court allowed when the parties that the delay can come 5 years also the Supreme Court considered.
No sir, what is the, you have claimed it?
Yes, sir.
Father should claim it. You can file separate. Asika also they can file. This was the part also you can file. Next suit also you can file. Yes sir.
Finding only that she is representing one fact, one more submission that the council on record is died will not much prior to this of this order. But court and that will not be the arguments of the two parties. Council on record died. I stated Milan there are 1988-2020. He died on 1988-20.
That was subsequent to filing of the petitions before the honorable HIGHCOURT.
Then you have to hear the matter sir. Read page number 6. This is petition coming before me on this day, hearing in the presence of Dr. B.S. Gopavaram. On the same day he expired. Okay, no.
By hearing the matter, counsel was there. And he also represented. And for the trial court.
Delay of 200 days. Start 206 days partition suit. You have to allow this. Here the counsel for the petition. You are not paying the counters last since 2.5 years, sir. When we filed Wakarat this case, where the person filing the and then January, no sir. January 2022 you filed. When you filed April 22. Now 1.5 years over. Not filed any counter. Yes, sir. Here the counter not necessary for every case in CRP. Here counsel for petition. Counsel for 6 times. Post for after 2 weeks. Meantime, 5.5.
Item number 18. MD Pratap Kumar. TC Mission.
Yes, sir. Who's the respondent, sir? Only up to what about others? Depend. Total 14. Only R2 filed Wakalat. R2, R3, R4, R5, R6, R7. R2 to 7 he filed Wakalat.
Council also was served.
No, R2, R2, R7 filed by the TC Krishnan. What about others? 8 to 14. Respondent number 8 and 12 shown as poster tracking, item returned unconscious. Inception address. Eighteen one to the 23. Remove 5. Item level confirmed. Econ certificate. To the publish. Notice. None of people will respond number. Total respond number. Most of the respond number 227. 127.
Item number 19, Reddy, and item number 20, C. Hanmantra, Sri Karnakar Komreddy, L. Venkateshwara.
Okay. Yes, madam. I think I have started hearing after before vacation. But 1610, Lennon Council appearing, presenting for the Lennon Council for the respondent submitted, the Lennon Council appearing for the respondent is not filed and push it time. Push it today. Number of agent matter, madam, before me, since June onwards. His colleague is here. He asked for number of times for adjournment. Today you are presenting. Yes, sir.
There are two cases, one is the jurisdiction of claims against as filed CRT, and one more.
Yes, sir. Well, CMA, before this bench, I have seen the point made by you.
Already petitioner counsel.
Sir, what shall sir, both your senior and Samatra want to argue the matter. Ready to argue. Last occasion. Post correspondent 6, post 2 weeks finally.
There is a video.
Item number 21 to 23, Ali Nageshwara, J. Pradeep Kiran.
Yes, sir. What is the contempt case sir, in this matter?
Where they already done all this. The contempt is filed. That's the
Please, sir, listed.
CC 1123 filed by my client.
Okay, you can also file the CC.
Yes, it was.
We can accept the CC right now.
CC then okay as per high CJ.
Because the land judge released even that contempt also.
No, I have no permission to call the other CC, sir. CC has to. Exactly.
It was released along with this batch.
No, only for CRP along with CRP number 314 along with CRP number 3242 and CC number 218 2023 only.
My instructions are separate order is passed in the CC to be posted along with it. And one more thing here before my grand senior begins. The compute order again which this against this CRP is filed 2342. The state they have sought for filing another IA in the trial court. This is against the interim custody granted to the father of this CRP.
Oh, maternal issue.
Yes, in a guardian OP. And last Tuesday they have filed an IA before the trial court itself, seeking custody of the child. So it is nothing but an abuse of process of the court. Let them choose one avenue, either whether they want to prosecute this CRP because that is well subsequent to this CRP. Right? It is under the assumption that they are going to withdraw this CRP. That should be the case. Otherwise, it is posted tomorrow because it would amount to clear abuse of process of the court. And one more thing. They have filed this visitation order against which this contempt is filed. The present contempt which is listed today. Yeah, that is just 1 minute for my land significance. That is pursuant and understanding that on 15th August we offered visitation, that is during the first hearing, 15th August, we offered visitation. Subsequently, both the councils mentioned that DLSA will not be functioning on 15th August. That's why it was consensually modified to 16th August. That happened to be Wednesday. So the same arrangement, because the subsequent hearings, it was on the land justice was under the impression that during the mediation it could be resolved. Mediation and hearings have been happening. So now we are filing I was out of, this matter was listed only Friday. I was out of station during the weekend and we have prepared, but I needed 1 day time limit seeking modification of that order because Wednesday my client, the father, is a senior bank employee. And it is becoming very difficult for him to honor the visitation on Wednesday. Still he is honoring, and 1 or 2 weeks he has requested to modify it to Saturday. So we are coming up with a petition to modify the same day Saturday.
If that we are not on the point of the modification of the ordinance, now we are
so I request
the CRP decided that nothing surprises in either of these petitions. Now it's a pathetic case where the
CRP. The first case 3142.
2342.
2342.
Against which the
yes, sir.
the mother in the petitioner, the mother of the child. The first respondent is the father of the child. The daughter is passed page 6 the definite case. Their application filed by them was partly allowed giving a visitation rights. Then another application is filed. Present application is filed in IA number 412 of 2022. See page 6 Operator portion at page 10 Miller says. Page 10.
Yes, sir. This para number?
Para 8. The previous petition filed by the petitioner, very same petitioner filed for custody of the child, was not given to the petitioner as the respondent number 1 contended that she was going to London to study a course. She returned as December 2022. Even as per the council, the respondent number has not returned to India by January 2023. And she was stated to be returning India February 2023. Though this court produced that a child before the court, the respondent number 1 has declared order of the still have neither appeared, but before the court not producing the child before this court, they contested the respondent number 1 has not remained unremitted. Further, the petitioner contended that he will take care of the child and his mother will assist him in taking care of the child. Further, the contention of the petition is that his mother gave an undertaking in the petition that she is ready to take on leave to look after the child, and she is even ready to resign her job to take care of the child, and she is ready to come to the court also the respondent in order to take care of him. As evidence from the record, the mother of the minor God is not available. She is very much available in India. Now she is very much present in the court also. The completion 1 month is the delay. The petitioner is the father and the natural guardian of the minor child. Those that are point contended that the responsibility they cannot take care. The further as the petitioner is the father, the natural guardian of the child, in the absence of the mother, he can take good care of the child and the nurture him and the welfare of the child. The custody of the child can be given to the petitioner only the ground that the child remained in the custody of the maternal grandparents for a long period. His request cannot be rejected. That's only on the ground that the.
So what is the age of the child? Age of the child?
4 years. 4 years. 4 years. The jurisdictional point, how they find the present application where there is there is no jurisdiction for the Rangareddy court to entertain the application. Admittedly, the petitioner is, what is staying with the mother and grandparents of Koda. If at all they want to seek custody of the child, they have to necessarily file an application in the district court of Suryapet, not in the Rangareddy court. How even the habeas corpus, they forcefully taken the custody of them, the habeas corpus is not right, and the habeas corpus was disposed of, they were forcefully taken custody of the child. How they treated the child in a cruel manner. The first question is that they note to the retrojurisdiction to the court authority to maintain the application under section 9 of the Guardian Warrant Act. That you have to make NDC on the jurisdiction point.
Jurisdiction point, sorry. They have filed an IA before the trial court challenging the jurisdiction, and it became final. They have not challenged it.
No time to answer that, man.
No, because.
No, don't do so. Huh? You don't want to argue today, itself? Huh? You're not ready?
Ready, I want to bring some more documents and other.
Then ask for time initially.
No, I was saying I need to file cover.
If you actually see the photographs filed along with the petition would indicate how the respondent is.
Senior person, we want only 2 weeks time. Grant 2 weeks time, the final.
The problem is, but the officers they are honoring it. They are not honoring it. That's the whole problem.
Doctor, madam, intimate sir.
Intimate is there. They are not doing the child last TV.
Yes, Kiran.
Only the even I will file the WhatsApp communications between my client and the petitioner hearing. He is only requesting Wednesday. I am unable to bring only for the last 2 weeks. That too, I will bring the child on Saturday. She is coming and staying in the DLSA on Wednesdays. She is not choosing to come on Saturday and Friday evening. Also, he is asking her whether you are coming tomorrow. Because there is no response, he is unable to take the child to DLSA. Only intent is to harass my client. I will file counter to the. I am filing a petition seeking modification of this visitation day from Wednesday to.
Back to the. Supreme Court last and other.
We have
Similar circumstances. Here the custom. The child cannot be bring the court side. Child to bring for to the ashram or temple instead of bringing that boy to the tender age.
Yes.
Already, even under the section 6A of the Hindu the ashram can see for if a boy is less than any child is less than 5 years age. That's the say. Section itself forbids to under the custody of the mother. Yes, I will read it and
Yes, but he is not ready to argue today. There's no problem. For the first time, I understand the case, but we want only.
The other thing, something to watch my learning. Case would be appeared in matter that we both considered before the court, saying that they are willing to give the custody of the boy race. In the brother, in the he can't say no.
Yes, sir.
Because he was also present. In the presence of their parties, Mr. K. Smoothie made a statement saying that they are ready to give the custody back to the mother, since the mother is very much here. So the learned again the matter to take to enable the this mother to file an undertaking saying that she will not leave the country. To that extent, the matter is adjourned to some other. Then they changed the version. Then Mr. Murthy is inclined to appeal before because he made a statement.
Yes, sir.
Saying that they are inclined to give back the.
The merits you can pass on. Most of the response 6 times. Post after 10 days after 10 days final. Sir, till sir, your final petition. Make arrangements for last 2 weeks, only 2 weeks.
Yes, these 2 weeks.
Yes, they are against that. Okay.
Communicating.
Current
The timings, no, the last minute, timings, they are not adhering to the timings given. Ordered by the school. They are avoiding only one hour.
So they're trying to say in WhatsApp all.
Okay, so 10 to 5, how can they sit in the fourth for your child? How can they sit, she sit for 10 to 5, when you will come, how can they know? You fix at a time.
That's what we are communicating every week in advance. That tomorrow I'm bringing from 10 or at 2, 3 hours. That tenderate child who is they are asking the child to be kept from morning 10 to evening 5 minutes.
There's something which is mother of the child.
Yes, yes.
It was very much in the custody of the mother
Yes, sir.
till the application is filed. Now the father give the custody of the child from 10 to 5.
So what is the earlier order, sir? I want to see, where is the earlier order?
May I request, I will file orders by this week, next Monday, this may be posted. Let this same arrangement be continued. We are seeking modifications to every alternative Saturday if they want 10 to 5.
Page 15, first respondent shall give instance rights to the petitioner on every Wednesday. Petitioner shall intimate the first respondent about our intention to meet the child well in advance. That is the orders passed by this court.
Yes, that's all.
Then there is not 3 hours time. You have to put it 10 to 5.
There is no time fixed.
Then
That's all.
the 10 to 5, sir, that means 10 to 5. Day. 10 to 5. Before DLSC means 4 hours.
LS hours are also 10 to 5.
And 10 to 5, you have to produce chair 10 to 5. Where the custody only 3 hours, 2 hours.
Sleep in the afternoon, sometimes if they
The mother will take care. Mother will take all these things. Mother will take care. She is mother. How can father sir? Yes, mother will take care. All these things.
had the mother been taking care of child well, there is no occasion for that.
No, no, sir.
It will be fine.
Dispute between not by. No, no, Kiran. Don't argue like that. No, no. I put not by the child with dispute with this child. Dispute with the older.
I will bring the conduct of due respect. I will bring the
Don't all
conduct.
this thing. Argue the matter, then we will see. Okay, sir. Let it continue. After 10 days. Post on 16 level. Post on. I will not change any orders, sir. Continue. On 16th, I will pass. On 16th, I will hear the matter, sir, both of you. I will pass orders.
Yes, the other content case, if there is an order, let them be filed before.
I have no position to say all the things, sir. He has to decide.
Inform the court officer that is also posted along that earlier court.
No, sir.
That this is.
It has to go to the again CJ, sir.
All the matters were.
Yes, yes, sir. Yes, sir. When do you want? 16th or 71, 70? When do you want? 14? Okay. Post on 14. What is 1 week? 14 weeks, 1 week. Yes.
Item number 24, Kiran Reddy Mallar, P. Kumar.
Next time ready, Kiran. You have to hear the matter.
If I'm bringing on records.
Yes.
Documents, otherwise I'm ready.
Not much, right? By buying from the court open for not. The cost of petition is it matters out of the court and no further respect this country. That is CRP this is purchase. Yes, sir.
Item number 25, yes, Surendra Reddy, V. Delta.
Do the respondents, sir. What is this case, sir?
When the signatures, with the signatures, and if it's very less than the signatures before the court on the other and the chief of court. The same petition was dismissed by the court.
Also the petitioner. Takes time. What for the 2 weeks?
Item number 26, Mohammed basic analysis.
We have it after a week's time, or first, where they will start with the case. We then can be disposed.
After pass judgment, consider
They are filing application beside the. We have been set expertise for the trial court. Thereafter, we find the application to set aside the expert about cause dismiss against which we have filed the legal petition.
so they have no urgency, plaintiffs have no urgency. Huh? So after stay, continue. Once per the respondent speaks and post officer 3 weeks. No election till then. The different guys have copy. Ask them. Huh?
Item number 27, G. Kishore Kumar.
Last second open for the petitioner. Yes, sir. No idea what this is. One of the 6 like post after 4 weeks.
Item number 28, 29, 30. In Mohammed Ali
Yes, sir.
Faruqi.
Kindly take item number 29, which is the lead one.
Okay, 17714.
Item number 29.
Yes.
This revision is filed against the injunction order.
Sir, I'm appealing for the Ali Faraz Faruqi.
Okay. Appealing for the petitioner.
First case on other side, sir. And 28 is other side. Right, right, other side.
29 merits per candidate.
Yes, sir.
In item 29, the CRP is directed against an injunction granted by the work tribunal restraining the present revision petitioners from interfering with the 8 mullies which are the subject property, and that suit is filed by a third party.
Interested party.
Interested person.
Yes.
Under the work act.
Yes.
Your Lordship may kindly see page number 115 of the paper book in this particular CRP. Before that, I'll just briefly tell the case.
Yes.
There is one Dastagir, my father, that is father of the revision petitioners. Dastagir has leased out the 8 mullies to different tenants. And he has filed eviction proceedings before the rent control court. And rent control court passed an order of eviction, which are final in the appeal also. It is required to be executed because Dastagir is the landlord as per the rent control court judgment.
Yes.
Then at that stage, after the eviction decrees are passed by the rent controller, Law Board files the suit, which is at page number 115.
Yes.
And at page 115, kindly see the cause title. The plaintiff is the State Work Board, and the first defendant is Mohammed Dastagir.
Yes.
And thereafter, Mohammed Khaja, sons of Sir Dastagir, and several other tenants.
There are many parties here, there are as many as 34 defendants. And can you see the prayers made in this particular suit? At page number 125. It is therefore prayed that the court may be pleased to A. To decree the suit in favor of the plaintiff, that is court, against defendant number 1, that is Dastagir, for declaration, declaring that the first defendant is not entitled to take over the possession of the suit A to H. These are technologies, properties from defendants 2 to 9, who are the tenants, respectively, either forcibly, illegally, or under the order and decree of the rent controller, since decided A to H properties are registered and notified work properties attached to Dargah Hazrat so and so situated at Filkana. Then prayer B. To decree suit for consequential permanent injunction against first defendant, Dastagir, restraining him, his agents, from taking over the possession of A to H properties from defendants 2 to 9. Well, defendants 2 to 9 are the tenants. Dastagir is the landlord who has obtained, who has been granted the eviction decree by the rent control court. Waqf board files the suit saying that these 8 maliks are waqf properties. So the Waqf board wants a declaration that they will be declared as the waqf properties and restrain Dastagir from taking possession under the rent control decrees from the tenants who are defendants 2 to 9 in the Waqf board suit. This suit is pending, but there are no entry funds. This suit is just pending. Then, now kindly see the suit from which this particular CRP arises, page number 66. This suit is filed from 2001 was pending. It is pending. Why is never part of 2001? Waqf board doesn't take interest, but it is pending. That is the first suit, earlier suit. Then, page 66. Let's file the present suit in which the present injunction order under appeal has been passed. And you see this page 66 claim, OS number 10 of 2020. Page 66 minute.
Yes, sir.
OS number 10 of 2020. This is also before the Waqf tribunal. Here the plaintiff is Javed Ahmad, interested person. And the defendant, first defendant is the Telangana State Waqf Board. Then, by the time this 2020 year came, Dastagir passed away. Therefore, Muhammad Dastagir died for LRs. Riyaz and Bar, who are the Indian business now, that is 2, 3, and 4 are sons or daughters of Dastagir. Then, the rest of the parties present in this suit are the tenants. Then, the prayer made in this particular suit. Now, can you see the cause of action at page 74 for this suit? Page 74, paragraph number 8, cause of action. The cause of action for this suit arose on 15/2/20 when Muhammad Dastagir, father of defendants 2 to 4, filed rent control case number 47 of 2003 for eviction against defendant number 17 in respect of the PB number so and so, which is part of institution in property. And on further inquiries, plaintiff also came to know that the father of defendant 4, without any title claim position, fraudulently alienated substantial property under fraudulently executed sale deeds and collision with some of the tenants of the subscheduled property under fraudulent eviction proceedings, obtaining possession of the subscheduled property, and surprisingly, defendant number 1, Telangana State Waqf Board, is not taking any steps to safeguard. Telangana State Waqf Board filed a suit for it, which I have shown to you, which has long back, as in 2001. It has taken legal steps. But other action here is because Telangana State Waqf Board is not taking steps to safeguard the waqf property. The interested person is filing the present suit. The prayers in the suit are at page number 76.
page 76, bottom of the page, plaintiff therefore place A to declare dispute schedule property is notified of property. Is
Order pending for civil court.
court file tribunal.
Court file before.
Court file originally is transferred to sub tribunal. That is page 115. At page 115, it is before the Andhra Pradesh State Work Tribunal. Now it is called Telangana Work Tribunal.
Okay, Work Tribunal, okay, same tribunal.
Same tribunal. This suit is pending. Third party, person interested, I agree with person, says, work board is not taking interest, therefore I am coming forward. And he wants the relief in favor of the work board only to declare that this suit schedule property is a notified work property. B. Grant perpetual injunctions restraining defendants 11 and 24 to their adherents from interfering with the peaceful function and management of Telangana State Work Board over the suit schedule property. Then next page, C, to cancel order dated 6/4/2004 in RC number 288 of 2002 passed by the Additional Rent Control Hyderabad. Then prayer D, to cancel order dated 27/7/2009 in RA number 203. These are all the eviction orders passed by the rent control courts. Then E, to declare that the documents, agreement of sale from general power of attorney, document number so and so, and sale deed dated 17/7/2007, agreement of sale and another sale deed is referred to here. All these sale deeds are null and void and not binding on the work board. This is the suit. In this suit, interlocutory application is filed, which is allowed by the work tribunal, against which merit the present revision is filed by the legal representatives of the second. The order under revision now is at page number 13.
Yes, sir.
In IA number 21 of 2020, in OS number 10 of 2020. The prayer in this interlocutory application is kindly see at page number 16. This petition filed under order 39 rule 1 and 2 read with intent to grant injunction restraining respondents 2 to 11 and 22 to 24, anyone claiming them from interfering with the peaceful position and management of respondent number 1. Respondent number 1 is the work board.
Yes, sir.
Through its tenants over the 8 Malgis, admitted 108 square yards, principal numbers such and such, situated at Field Thana, Begum Bazar, Hyderabad, bounded by soil. Then, there is no interlocutory order in this suit also.
Yes, sir. Page number 132, all are dismissed in that application. Page 132, you are not brought notice. 132, again. This was all are dismissed in the year 2001, sir. Page number 132.
The work board suit.
Yes, support suit.
Yes. But this interlocutory application is allowed.
But not also the same order in the court.
Confirmed by the honorable High Court.
Work board's injunction application has been dismissed.
Dismissed, yes, sir.
Now, another injunction application by the interested person.
After 20 years.
20 years, and the work tribunal allows this injunction application, and you see the operating portion at page number 30. Result.
Yes, sir. Yes.
In the result, petition is allowed. Temporary injunction is issued restraining respondents 2, 4 to 11, 22 to 24. Anyone claiming through them from interfering with the peaceful position and management of respondent number 1, that is work board, through its tenants over the 8 subject Malgis till the disposal of the suit. Interim injunction grant is made actually. But this is a contradictory order, and this is an order which even work board has failed to take. So this person cannot have a higher pedestal, and his suit itself is totally based on ulterior considerations. Interested person asking the relief for the work board only. Work board already initiated the suit for 20 years, the suit is pending. And the court below, that is work tribunal, Let's discuss a prima facie case like this. At page number 21. Then the heading prima facie case. Prima facie case means the contention which the plaintiff is raising require consideration in merits. The present case, the petitioner is a person interested in the subject matter, stating that it is work property. At this stage, it is necessary to see section 3K of the work fact, that is person interested definition that your worship will kindly skip. Then thereafter, para 16. The claim of the petitioner is that the property involved in the petition is work property and there were alienations of the work property illegally. Therefore, file the main suit and the present suit. The petitioner exhibits P1 to P14 documents in support of this claim. He claims alienation of the work property without any manner of writing. Then there is a table that your worship may kindly skip over. Would kindly go to page 24. Balance of convenience. Before the balance of convenience starts, the conclusion on prima facie case. Last 4 lines before the caption balance of convenience. But keeping in view the documents above having definite finding, since the petitioner claims the subject matter is
page number, sir. Sir, page number
24. Page number 24.
25, sir.
Running page 24, internal page 12 of 21.
Yes, sir.
In that column, at the bottom of the page, there is a subheading balance of convenience. 4 lines before the balance of convenience starts. But keeping in view the documents referred above, without giving definite finding, finding and balance of convenience is not given. Without definite finding, since the petitioner claims subject multis as work property, we hold that the petitioner has established prima facie case in this paper. Then, balance of convenience. On the balance of convenience, the finding is at page number 27, paragraph number 24. In the present petition, the documents filed by both parties show, prima facie show that different proceedings are initiated by different parties in different forums, claiming that the subject property is work property on one hand and it is private property on the other hand. But there was no comprehensive suit like arbitrary suit which is pending. Thus, the veracity of all the judgments of different forums will only have to be decided by this tribunal in the suit. Keeping in view these factors, we hold that the balance of convenience is irreparable. Then, irreparable loss and hardship. That is the heading. Finding at page number 30, para 26. The injury complained of cannot be compensated in terms of money. Therefore, we hold that irreparable hardship would be caused to the petitioner if temporary injunction is not granted. The petitioner has established all the 3 principles, and therefore the petitioner is attending for temporary injunction. In the result, petition is allowed. Temporary injunction is granted. Restraining respondents 2 to 4 who are custodial sons and 11, 22, 24 tenants, anyone claiming to them from interfering with the peaceful position and the management of respondent number 1, which is work code, to its tenants over the 8 years till the disposal of the suit. But this order, with my respectful submission, is sustainable in law for several reasons. First is, work code is already litigating the matter and failed to obtain the injunction. Its petition was dismissed, and work code says that there are 8 tenants, 8 is on this scheduled property, and there are rent control proceedings initiated by the SAGE against the tenants, which are at the stage of execution. The tenants who failed in the rent control proceedings here who have made this particular interested person initiate this particular suit to protect their continuance on possession of these monies and to avoid the execution of the rent control decrees which are already supported by them, informed by the appellate court also. Here, the entire order does not show how that injunction is granted when a person has got personal interest over the property as per section 41 H. Injunction is refused when the person does not, now he is an interested person. What is the person claiming title? It is yet to be decided whether it is work property or private property of the second.
Yes.
That is, before that period, the cart is put before the horse. The injunction is granted now, is meant not for this particular interest person. It is in the interest of the tenants who have paid before the rent control. Because he is mainly asking for cancellation of the rent control orders, which the tribunal cannot grant for it. Rent control eviction orders are subject to appeal and revision for this on court. Tribunal has absolutely no jurisdiction, but the main player in this suit, which I have shown at page 66, is to cancel eviction decrees that are passed through the rent control courts. So, let's say the case balance is conveyed, and it is intended only to prevent the execution of the rent control decrees, which the Waqf board has attempted and failed. Therefore, this injunction will be released.
What is next case? Two matters?
That is a different case in the sense that is, there are two suits. Waqf board suit is there and this suit is there. Section 10 petition is filed before the lower court to stay the suit filed by the interested person, because the Waqf board suit is earlier point of time. The section 10 minute, the earlier suit will be taken up by the court, and the second suit will be stayed till the earlier suit is adjudicated sub judice. The petition filed under section 10 was allowed. That section 10 petition is allowed, and this suit in OS number 10 has been stayed. Because the other suit filed by the Waqf board is pending. Against the allowing of the petition CRP number 620 of 2023.
What about other side?
Is filed by the
Other
interested person.
What about item 30, sir?
Item 30.
1829.
Item 28 will is.
Lord, item number 28 is filed by me.
Yes, sir. Actually.
29 means I have not something in my hand, but my arguments may be posted tomorrow. This petition.
So what about the item? CRP number 1829.
Is also filed by the sons of the second. Against.
In subject matter property, the tenants have already also got the injection on. Against which Mrs. Dasagir has referred to CRP.
Difference to OS number 21.
Difference is that is a suit for injunction filed by one of the subtenant against the sons of Dasagir. That injunction was granted. Is at page number, if your object takes the file of CRP number 1829 of 2022, page 9.
Yes, sir.
This that is the injunction in IA number 107 of 20 in OS number 21. Here was OS number 20.
10, sir. 10.
10 of 20. Here it is 20. Here it is OS number 21 of 20 filed by one Zad Ahmad, who is a subtenant with a prayer at page number 10. To grant temporary injunction restraining the respondents, that is Dasagir sons, from interfering with the position and enjoyment over the Malgi. Only one Malgi, there were 8 Malgis there. Situated at Nasruddin's place, and only injunction. And in this, the Waqf tribunal, page number 23, grants an injunction.
Yes.
So overlooking all the rent control eviction was reasons.
against this particular plaintiff Canine Wallet, who is the petitioner in this petition, there is an execution petition pending in the rent control proceedings. So, in order to avoid the execution, eviction, the Rent Control Act, filed this petition and the lower court granted the tribunal granted extension, restraining respondents' justification from interfering with the position and enjoyment of that particular one multi subtenant. This goes the companion case led to the other one which I argued. Yes, sir. And once we are filed by them against staying of the second suit because first suit is pending. Yes, sir.
For my arguments tomorrow.
Why, sir?
Because item number 29 and 35 is not pending. Posted in the name is tomorrow.
Not tomorrow. Starting third set. After hearing senior counsel after 20 minutes. No, sir, he has to give his answer to your arguments also. Senior has to argue again. Huh? For the petition item 29, 30. Cost for the petition item 26, 10. Post after 10 days. And here, yes, sir.
I don't have a G16 or any other. Yeah, within the
So it seems that this time also this number 1 dependent 7 absent. Only once he has appeared, 30th junior, in requesting lordship. Even my item is not post under caption of orders. In convincing this law, the minister on my side, this is a shoot filed by me in the year 2014.
Before vacation, I hear you, sir. I have not always arguments. Now, what is your case then? Tell me.
Lordship, this matter filed on 24th February 23 lordship.
No, I have heard you, but
no, my endeavor is lordship. I only want to bring to the lordship kind notice that the totally mind game of the respondent counsel lordship. The lordship kindly follow the orders of hearing my arguments. Again, submitting sincerely before your lordship. Because the question of law is without absence of pleadings in the written statements, the additional issues cannot be framed. This is the only law. The lordship aware that I have also passed on the relevant judgment lordship. See, he has filed the to give the additional issues under order 40 group 5, which is subject to provisions of the section 9, section 21, order 8 to 14 to order 14.1, 7.11, all these subject to without consideration provision of CPC and establishing law is simply considered the court below. Not sustained under law, in the F law. But the reason why the other side is not appearing, because this is my case has been stalled because filed in the 2014, I am not able to proceed, allow the request to the below to proceed the proceedings of the suit.
there is no stay, sir.
Stay there. Stay for the proceedings.
Huh?
That is on 27/4/23.
27/4.
Yes.
Okay. 25/4, 26/4, no stay 27.
Already brought your lordship is that still admitted that they will not pay anything with regard to the state tax list. Page number 18.
Page number?
Page number 18. The IM filed by the debit of the IM filed by the trend number 1, contracts. Trend number 7, section 18. You can see the 19. So the additional issues regarding non-gender of asset parties, non-gender of other gender properties.
Suit for?
suit for partial substitution. Moreover, the dependent server is a third party lordship. He has nothing, he has no interest at all, he is not at all concerned, he is not the member of the family, joint family. He only purchases the undue interest of the dependent number 7. Just he intentionally just to prolong the suit. Because the 3 brothers, without giving sharing to sisters, they are sold away. That is the reason why he wanted to prolong the matter. See, regarding these additional issues, Lordship, it's a rating in the page number 18, para 3, 5th line, Lordship, he himself admitted that I have not stated in a letter stated Lordship, I see 5th line of the third para. I submit that, Lordship got it. Yes, the 5th line. I submit that being a purchaser, I am not aware of all the properties of all the others, one of the creative dependents. All the legalities of late are revealed here. And as such, I have not taken the place of non-fair properties. Himself admitting, I have identified the written statement filed by him. Nobody stated himself, when he is himself admitting that he has not stated as per law, Order 8 Rule 2, he cannot challenge the issue now. After a gap of 9 years, law will not permit.
Para 4, sir.
Para 4. I submit that the commencement of the case trial, I learned that the earlier sister of plaintiff, Alvin is having 4 daughters. That's what regarding 4 daughters. His son is only pleaded. See, the plaintiff has 3 brothers, 2 sisters. 5th one is the elder sister. Elder sister is pleaded. You wanted to the daughters only, but that has to be stated in the dependent in the written statement specifically. Unless and until, because in order to frame issues and actual issues, the issue framing of issues would only arise where the question of fact and the law should be asserted by one party and by other party, like in pleadings. And second one, and that has to be pleaded, has to take the dependent, especially in the written statement. Unless and until that, so the actual issues cannot be framed in the law. Also, transformation I passed on the relevant judgment, Lordship.
2006 480 judgment. What is para?
No judgment, Lordship. So the judgment is rendered by the Lordship of the Nationality. Lordship say 6 pair, 6 Lordship. Para 6. Relevant. 6. Made it, Lordship. Yes. It is difficult to accept the contention of the land counsel for the petitioner that issues touching on the judicial can be framed. Even it must be noted that Section 9 of CPC confers jurisdiction on the same course to entertain suits of every category, unless they are specifically accepted by any federal law. Section 9 clearly states that, Lordship, civil court can take any suit unless it is excluded law. Because this my case is that similarly, under 8 Rule 2 and 14th one excluded because barred by law, never continues. Unless Section 21 mandates that any application as to territorial jurisdiction must be raised at the earliest point of time. So this issue is not with the judicial issue. Rule 2 of Order 8 requires that it's a relevant provision. Any objection as to maintainability must be specifically raised in written statement. That is why that are being issued every time. Makes it clear that the necessity to frame an issue would arise if only there is assertion by one party and denial by another. Such assertions and denials can be only through pleadings. CPC does not recognize any other mode in this regard. In the absence of any pleading in the plaint or intersection, the trial court is virtually helpless in the matter of framing issues. The last next go to the para number 7. There may be exceptional cases where the court itself can formulate an issue if the matter can be brought within the scope of Rule 11 or Order 7. If any other specially because rules Order 7 Rule 11 has to invoke the provision if any special admittedly, the petitioner did not raise any plea as to lack of jurisdiction in the trial court. If for any reasons he wanted to do so, he ought to have taken necessary steps to amend his written statement. Without taking such steps, the court he cannot expect the court to frame an issue. Hence, the court does not find any basis to get the under the provision. Clearly stated. So this law is well established in this regard. Provisions of the cities also states Absence of pleading, sir, these are special fee. Additional fees cannot be taken up with court below. So he committed another serious clarity law. Therefore, I reach lordship in absence of this dismissal council also will not be finding all the orders on merits.
Here comes for petition. To the respondent. Post orders after 2 weeks.
Yes, below.
Item number 32, B. Venkateswara Agarwal Abhishek.
They have written suit for trademarks changes for the enforcement of the trademarks. I filed an application note under 39-182 seeking injunction. The injunction is granted retaining the respondents from using the deceptive single trademark. Argued by the same one, they preferred an appeal before this court. Appeal is also dismissed. But I have also filed an execution petition seeking to execute the order. But challenging the execution proceedings, they prefer the present CRP, stating that the orders which was passed by the trial court as well as non-executable order. They want to use the same trademark until the final outcome of the suit. That's what the ground says.
Trademark Santosh. What is Santosh?
Santosh Dava, this is Santosh Dava matter.
Okay, Santosh Dava. Habit Santosh Dava. Habit Santosh Dava.
Everyone is using Santosh Dava. Now the exclusive of trademarks is with habit Santosh Dava.
Since how many years, sir?
Since several years,
yes. A case that have
several cases was filed by
campus.
Several cases was filed, injunction was granted, appeal was also confirmed in the favor of Santosh Dava. They want to the grounds what they file in the present CRP says that they want to use the trademark until disposal of the suit. The interim orders are not executable. In such event, there is
okay, sir. Post after 2 weeks.
Let's say interim orders are there, stalling the execution proceedings.
Sir, you're not filed any vacant petition also, I think.
No, sir, I am ready to argue the matter itself.
Coming from April onwards. Okay, wait for 2 more weeks. Possibly the 6th time.
They are asking for day after tomorrow.
No, sir, 2 weeks, sir. 2 weeks, after 2 weeks. 4 matters after 2 weeks. No, madam. I have seen.
Item number 36, Narendra Nil.
After 6 weeks, after 6 months, they will have. I think already over, but.
Their petition.
What is CRP? What is IA?
There is the passed by the child collector.
In? Exam set.
Okay, now, Minutes Act.
38 certificate.
38-year certificate has been challenged after 25 years. There was dismissed by the joint collector, saying that there is an abnormal delay, it cannot be controlled. Lordship, they constitutional matter was argued, they did not file the limitation petition. Someone is petition around the CRC. Then you are directed to more or less.
Open the state tax, 402 weeks. You are in there. 2 weeks.
They are taking into what it may be one petition, suggesting after 25 years they file an appeal. The delay.
I think you are on the question of the property. Continue. Huh? You are on the question of the property, I think. Huh? Yes. Continue. Okay.
Item number 37, Naresh Kumar. G. Naresh Kumar.
Yes, sir. 2 weeks. 10, 20 years.
Item number 37, Naresh Kumar. T. Naresh Kumar.
Yes, sir.
But this present of CRP is filed against the orders passed in CMA. Number 24 of 2002, which is page number 2, page number 12. But against the orders in passed in IA, 938 of 2018, in OS number 193. I find a suit for injunction, simple injunction here. Along with an IA. I filed the documents, your lordship, please to see at page number 30. And your lordship, this is the plain copy which I filed, your lordship. Suit for perpetual injunction, OS number 193 of 2018, page number 37, your lordship. These are the documents I have filed along with my claim. Almost all are brought certified copies, your lordship. Almost 10 copies are certified copies of the registered sale deeds. And these documents are the respondent filed the counter. The respondent also filed the documents, I am not denying it. But the order passed in IA is at page number 18, your lordship. Page number 8. Is the order in IA. But it's very unfortunate the finding at page number 26. The court says that no single document has been filed either by the petitioner or by the respondent. That is the finding. I have filed this.
Normally, marking of documents in the IA, sir.
That has been done, your lordship. That has been done.
Not marked in the document order.
That's a finding before your lordship. I have raised this point in the CMA also. CMA grounds I specifically raised that I have filed the documents along with the suit itself, that two certified copies and some original documents.
What is the answer by the?
There is no answer. That's my grievance, your lordship.
Show me.
This is at page number 12, your lordship. Court does not give any answer, your lordship. My grounds, I would like to take your lordship at page number 15. First, I would like to take your lordship at page number 15. The CMA, this is CMA for additional district judge. Point number 4, your lordship, ground.
Yes, sir.
The learned trial court erroneously came to conclusion that both parties failed to produce any documentary evidence in respect to their position as against the petitioner apparent finding several documents in proof of their claim in the form of both original as well as the certified copies, which is evident from the list of the documents, docket of the suit, describing the nature of the documents filed by the respondent. Again, I have reiterated at ground number 9. The learned trial court failed to appreciate that the documents filed by the respondent before the learned trial does not support the case. But here, it's not the case that I did not file. But we both filed. The court came to the conclusion that none of you filed. And there is no finding in this particular ground which I have taken, not in the CMA. The CMA order is at page 9 and 10, 9, 10, 11 mirror. And the court says that at page number 12, your lordship, page number 12, operative portion. Court says that in such circumstances,
Page 11, para 15, sir.
yes, your lord. The petitioner filed the present application seeking injunction instead respondents from interfering in the peaceful position or the scheduled property in the instance application. The burden lies on the petitioner to prove the position as in the letter of the petitioner criteria, so and so. As a settled principle that the petitioner should not depend upon the weakness of the respondents. Already agreed as discussed. No documents have been put before the petitioner.
Put forth by the
Yes, as already
petitioner to believe the substantive.
Court come to the conclusion in this case
that I have not filed the documents, my lord, where my documents have gone, my lord, I have filed all the certified copies, I have taken a plea, my lord, at the most court should have said that where are your documents? But in fact, before in the CMA also, but I have filed the documents. But next also, but it's there, page number 12, last 4 lines. This dispute between the two parties can't be decided since the parties are disputing their with regard to the same property without the help or need of the document.
Since the parties did not choose to mark any document support of their claim, the Grand Trial Court could not arrive at the different opinion.
But in fact, at the time of arguments, my lord, in the IA, my lord, documents were, my lord, without the documents, the question of arguing doesn't arise.
The marking of documents, sir, not mark, that is the point. Not marked. Not by the petition, the marking of the document, that is the only point.
Yes. In the case, your lordship, on the matter,
They are marked, it's document to mark.
yes, that's the only.
Yes, sir.
May I please your lordships? Under law, your lordships, what cannot be achieved directly cannot be achieved indirectly.
Yes, sir.
That is the attempt made by the petitioner's theory. The petitioner, your lordships, purchases a property. This matter is pending before passing your lordships. While pending, they have come to the civil court, your lordships. Just small gist before I go into the minutes of this IA, your lordships.
Before the artist cases are pending?
Yes, your lordships. The case is like this. The petitioner herein purchases the property from their vendors, who in turn purchases from a auction purchaser. Auction purchaser's property got set aside. The sale certificate of the auction purchaser gets set aside, your lordships. The bank prefers an appeal on it. The appeal gets dismissed. Meanwhile, your lordships, the auction purchaser sells the property to the vendors of these petitioners. The vendors of these petitioners, when they have when the auction purchaser actually purchased it, when the recovery advocate commissioner was appointed came on to the to my land to taking possession of it, I prefer an appeal before the recovery officer. See, this is my property. The auction purchaser, based on sales market, is coming to my property. It is not his property. So my application is allowed. On that application, the banker prefers an appeal. The banker's appeal is dismissed. Why this is happening, your lordships? When the sales certificate is dismissed, and once the sales certificate is get dismissed, your lordships, there is no title being given. There is no legal title passed on to his vendors. When his vendors are not passed on legal title, your lordships, the present petitioners will not get a title. These were the documents that I have filed before the court in IA number so and so, your lordships. So while if at all you have agreed by the order of your vendor has not got the title in the property, if you are agreed by it, and when a case is pending on the same property before the DRB, you are supposed to make an application there. But instead of preferring it, your lordships, that appeal which the banker has filed, they dismissed in 2009. In 2018, strangely, your lordships, against the vendor, against his vendor, against whom I filed an appeal, he was a party. His vendor was a party there. His vendor was a party there. That the suit filed by the banker.
There was cancelled. What is the date of this?
2009, your lordships.
2009, Senator cancelled.
Sales certificate was cancelled.
When was the petition purchased the property?
Yes.
This petition, 2007, he purchases, your lordships.
2007, he
purchases. But the sales certificate precedes the purchasing, your lordships. 2006 sales certificate. Ultimately, get set aside. So when your sales certificate is set aside, then when your vendor itself has not got the title, how come you will get a title on that? And now strangely they come and say after 2009, 2019, they come with some photographs saying that I am coming and interfering with the property. They have not. I am in possession of it.
What is Shush property?
Shush property, your lordship, is 11 guntas, 222.
Look at the look at the land. 11 guntas.
11 guntas.
Then
it's there, your lordship. It's in my possession. Now, suddenly, after 2009, 2018, the vendors against whom I filed
matter which was pending before the Sarfasi Act. They didn't choose to, neither the banker choose to make an appeal, neither the auction purchaser choose to make an appeal, neither the purchasers who purchase the property from the auction purchaser choose to make an appeal, neither the subsequent purchasers make any attempt going to the DRT. Suddenly, they came to the civil court along with an IA and suit. In the IA, your lordship will kindly see the categorical order, very fine order has been given by the lower court, your lordship. Appreciable order, your lordship. Kindly go to at page number 56, your lordship, of that order. Page number 26, your lordship. Yes. Your lordship, about it, internal page number 9. Here, your lordship, the lower court now says that it will over. If I pass an order in this IA, the second line, it will overcome the orders passed by the honorable recovery officer. That's the fancy. This is the first ground of rejection. Then your lordship, the second ground of rejection is 6th line. To prove the same, there is no such single document filed by the petitioners. The documents filed by the petitioners are Xerox copies and some are photocopies. But how the documents are relevant to the facts of this case are also not explained to this court. Moreover, no perusal of these documents. On perusal of these documents, there are many issues to be decided between the petitioners, respondents, and also State Bank of Hyderabad Saharanpur branch is also a party to the disputed OA 477 of 475 of 2000. Therefore, without proceeding trial, it cannot be decided at this stage. So the second ground of rejection is your lordship. You filed the photocopies. But these perusal, where perusal of these photocopies, I cannot grant you a temporary injunction of. Second ground of rejection. Third ground is, as you both say that it's a property. See, I say that it's not a property of State Bank of Hyderabad. You say you have got it from State Bank of Hyderabad. So there is some dispute. So until unless I hear State Bank of Hyderabad, I cannot give an order. Third ground of rejection in the IA. The fourth may be seen, your lordship. Without proceeding trial, it cannot be said at this stage. And moreover, the petitioner seeking the relief in this petition is to grant a temporary injunction by restraining the respondents from interfering into their peaceful possession and enjoyment of the petitioner's property. And the main suit also, the petitioner is seeking permanent perpetual injunction by restraining the defendants, their agents, henchmen, so and so from it. So the relief in IE and main suit are one and the same. Once this petition is disposed of, there will be no relief remains to the petitioners to proceed with the trial. So this is the first ground of rejection. So it is not that your lordship, they were not heard of, documents were not taken into consideration. Now, the appeal has been prepared on the ground saying that, see, my documents, where certified copies I have filed, are some original paper, they are marked. That is the ground on which the CMO was preferred. The CMO got displeasure. See, these are the four. See, had they gone with the trial by this time, 2019, the suit would have come to a conclusion. The suit would have come to a conclusion. They are not interested in proceeding with the suit. They are only interested in proceeding with the IA. They preferred a CMA, they lost there, now they are. This is the abuse process of the law and wasted with the court's time, precious time with the court being wasted. I made the same request. If they are so interested, let a time frame be fixed in the OS and it be finished. I am ready with the trial. I am ready with my documents.
You are event number 1 or 2, sir?
You are for both the respondents.
One submission here also. Page number 25 may not. There no documents are filed by both the parties. How there will be a finding in respect to the order, in respect to this RPA order, your lordship? On one hand, court says that there are documents. On the other hand, they said that there are no documents.
Sir, once.
Page number 25, your lordship.
One doubt, sir. Yes. Once for civil property, DRT before the DRT RA, what is RA pending?
Oh, yes, OA for civil. RA 5
2009 pending.
Pending, your lordship. Pending.
I purchased,
It is pending with Sarfas and Sarfas Act. Okay, so civil court and jurisdiction to entertain this suit.
That proceedings is going on. This is only a injunction suit here also.
Moreover, SBI is not a party. SBI is not a party.
Let there be an order on merits basing upon the documents what are. My only grievance to that extent before your order. Let there be an order. Let it be dismissed. Let it consider my documents. But this is not the stage and this is not the court where Lord, I can argue on merits.
Yes, sir.
Lord, oblige your lordship. This is not the stage. Lord, I have another forum. The matter is being adjudicated. Lord, here, definitely there is an ambiguity in the order passed, Lord, in the lower court. It can't rely upon the documents which are not filed. On one hand, it says, Lord, page number 25, your lordship, please to see. Page number 25, parasecond. However, in this petition, both parties failed to file any original or certified copies of sale deeds before this court to mark the same. But both are admitted with regard to the suit so and so. This is the case. When both the parties have not filed, where is the question of order on minutes?
Certificate copy is page number 37 is showing 37 CC, all CCs.
All CCs, but I have filed it. That I have filed your lordship. I filed certified copies. Well, let them be in order on merits.
Yes.
But that's only 3 months before your lordship.
Yes, marking and cross orders.
Yes.
May please, Your Honor. This views of the person. When a matter is pending there, how come is OS or
Sir, I am concerned with only IA order. Page number 25 first paragraph, just to see the course read. Read page number 25 first paragraph, second paragraph, 2 lines.
However, in this petition,
Yes.
both parties failed to file any original or certified copies of the deeds. So this court will may mark the same.
Mark, yes.
But both are admitting.
1 minute, page number 37, see the page number 37. List of documents along with suit, plain copy. Page 37. Yes.
This is the list of documents that are
Next column, right side column.
CC of DRT memo.
CC means what is the CC?
And this certified copy.
Then what, how can they say that there is no certificate copies of the documents?
When I have been to your lordship, when I have been
not present for
in the lower court, your lordship, each number line categorical order has been given that none of
these
these
are also orders of the lower court only. See the page 20, continue read second line. Page 25, read second line.
with regard to the suit filed by State Bank of Hyderabad and pending of proceedings under the RA. Therefore, as per the above said version, the dispute is pending with the parties before the recovery officer, Deputy Tribunal, and this petition.
Sir, don't read all this. However, this petition, both parties failed to file any original or certified copies of sale deeds before this court to mark. What is the meaning of to mark? Not marking the documents in spite of filing certified copies by the.
They should come forward, get the certified copies to the court. Just making a mention in the docket saying that I have get certified copy doesn't mean that you have to come before.
You have to file copies.
They've been filing. That is what the court says. If I have the documents, I have seen with my eyes, I would have marked it. Just they have made a mention that certified copy. Where is the certified copy? Had the court seen the certified copy, it could have got marked. List of documents mentioned, but at the time when the IA is argued, the documents to be marked. Where is it?
Along with the copy, they have to file.
If that has been.
Then I will call for the records. Then I will call for the records.
Much obliged, please come.
Then call for the records. As possible posters. Should I do to call for the records from the trial court? Regard to the OS number 197/2018. Along with list of documents. Post after 4 weeks.
Item number 38 and 39, M. Damodar Reddy V. Hanmantrao.
Is not just now EP proceeding and the party. We have all further proceeding. Again, another EP was filed. Then, my execution of the expert. I have already filed IA for setting aside of the expert degree. Pending at IA blood, they have initiated.
It was expired in the month of August, sir. Expired in the month of August. First time, sir. 88.
The last time we extend up to next
18/7/2023. Given the estimate till then means posted on 8/8. And 8/8 posted along with the CRP number so and so on 10/8. 19/8 is the cost of for the petitioners. Posted on 2 weeks. 19 12 petitioners and post on 15/9. Again listed on 9/10 is the cost of posted today. Given expired long back 4 months, 3 months back. Post for the respondent 6 and post after 2 weeks.
Item number 46 must follow this limit is removed.
Yes, sir.
This matter I am a respondent. I filed my counter. I am requesting next week only will submit.
First time before me.
Yes, ma'am.
What is CRP, sir?
Suppose that. That's also sit together.
Okay, COP.
Interim maintenance minute as is.
Yes, but exorbitant granting of. Sit together. I'm trying to.
Only 1 lakh per month.
Each.
1 lakh per small case.
7 lakhs is the
2 lakhs per
income
month.
of the husband. 7 lakhs. 2 lakhs is very.
Whatever amount you have asked by the petitioner, responded.
Okay, now you are. There is no intimacy in favor. Okay.
No, coming for admission only. Next
First for the respondent 6 and post after 2 weeks.
Yes.
Meantime, settle the matter, sir.
There is a request.
Right, certainly.
Yes, sir.
Answers on all, the parties will be really happy.
Yes, sir.
Item number 41. K. Ajay Kumar Annapurna Street of
First response, filed against it. Respondent may be permitted to withdraw the.
What is IA2? How many days delay? IA2, IA41. Yes, IA2. Take of business plans, disaster, undo. Airport. Air competition respondent. Petitioner permitted to. What was the petitioner, madam? Okay, climate one. Okay. Is permitted to withdraw the most qualified. Standard public complaint. As the author reported 14/8/2023 in IA number 3/2023 in ACMA number 2023. The account of MUOP number 3/19. New MUOP number 167 volt. On the file of what actions stands to run. Some 4th additional decisions at Nalgonda without punishing any surety. In case admit post of time after 8 weeks, meantime, is covered by the court below. Yes.
item number 42. Yes, Srinivas Reddy, yes, Surendra Reddy.
Yes, sir. Yes, please. How many days? 253 days. Yes, sir. To hear corporate respondents, we have to this condone. Because the respondent of this is our sector. So the most well respondent of the apply. As of this quote in 22/9/2023 in IN number 3/2023 in MSCM number 2/1/2023. The account of MUOP number 299/2019 on the file of chairman. Additional motor actors steps to the possession of district assistance and level without furnishing any activity. In case admit post for filing after 8 weeks, this is a card of the report below.
Item number 43. G. Sudipura, T. Butchreddy, T.
Yes,
Butchreddy,
one
from Raleigh.
infrastructure. Subsequent suit which has been now the part we transferred to that case has been disposed of on 11/7/2019. And the appeal is also before this honorable court, that is AS 520.
Okay, last time it was 11.
Yes.
Yes, sir.
Go back. There is no.
You are representing?
Respect of one, I have just verified, these suit OS 30
8 of 2019 has been sought to be transferred right to be along with this OS 36 of 2017 pending in the Karimnagar court. That OS 36 pending in the Karimnagar has been disposed of on.
What about present suit? What about the OS number 308? They are still pending.
Still pending.
Okay.
36 is disposed of because nothing remains even if it is transferred.
Counsel for the respondents submits the present no counsel petition as counsel submits the present the petition after the OS number 38 of 2009 on the file of 14 additional TSHC bracket FTC TSHC Court Hyderabad and transfer the same to the third additional TSHC Telangana to be clubbed with tied along with OS number 336 of 2007. But the suit pending before the third additional TSHC Telangana OS numbers of 2007 are disposed
11/7/2019.
on 11/7/2019 and same as pending before the appellate court.
Before this court.
Okay. And the agreed party filed appeal
Yes.
before this court same as number as AS number
520 of 2019.
520 of 2019. You have the same. The last petition is becoming for also respondents. This was the infectious.
Item 44 adjourned. Item number 45 hearing 150 D Ramakrishna.
Lordship, I am representing the counsel for the petitioner. Lordship, may place your Lordship, petitioner before your Lordship, his wife, and respondent in FCOP to 153 of 2019, pending before the family court of Elbinagar. And the present transfer petition is filed by the wife Lordship to transfer the FCOP from family court of Elbinagar to family court of Nalgonda. Because Lordship, you have to say the petitioner is an unemployed lady and she is staying with her.
What is status of the present OP, sir? 2019 OP. What is the present stage? We are in 2023.
Evidence has not been started.
True.
Yes, Lordship. And Lordship, kindly see page number 25.
Page number
25, Lordship. These are the reports of the petitioner's father, Lordship. He is a heart patient. He is a 73-year-old man. And if at all she has to come to Hyderabad, he has to accompany her. And it is very difficult to travel from Nalgonda to Hyderabad, Lordship, because she is not having any money and she is surviving on her father's money. And it is very difficult for her to come to Hyderabad with her father because he is a diabetic patient. And also,
what is status of the OP, sir? This e-court status. 2019 OP, we don't know. Huh?
Lordship, it is evidence has not been started, Lordship. Maintenance order also is not been ordered yet. Since 2 years it is pending.
Okay. Followed by the maintenance petition also.
This Lordship in page number 19, Lordship.
Who for the respondents? Air counsel petitioner. None of the respondents. Both the respondents. Both the orders after 2 weeks. Madam Subhashini, don't open your unmute your camera. Unmute your camera, madam.
Item number 46, Dr. 130.
The matter is been settled and mutual consent divorce has been already taken up. I pray the Honorable Court to dispose the case.
Boss, you're appealing for item 46?
I'm the petitioner, Your Honor.
Item number 46. What is
Yes,
item?
I'm the petitioner.
No.30 Venkareddy is petition, madam, here. What's the petitioner? You are?
Yeah.
What is your item number, madam?
56, Your Honor.
This is now 46, but not 56. Wait for your turn. Yes, sir. Also, petition submit, sir. Wait, one second. This is a
Item number 47, D. Sudarshan, V.Y. Krishna Sai.
Yes.
Lordship, meanwhile, stay. If we granted your lordship.
Wait, sir, wait. Reference over.
This is the wife hearing, Your Lordship. Petitioners have already filed in CC on the file of Judicial First Magistrate, Your Lordship, the Manipuru. Trial is yet to begin, Your Lordship. So she has to attend that the Manipur as well, Your Lordship. She's not having any source of income, which is like she has been depending on her parents, Your Lordship. Anyways, she has to attend the Manipur station.
Case cannot appeal only for the Hyderabad only.
Lordship, there is an CC number 283 of 2021 filed for the wife, Your Lordship.
Okay, Manuguru.
Yes, Your Lordship. Where the trial has been begun, Your Lordship. Anyways, she has to attend that court and even the husband has to attend.
Only one time for the trial, madam, in criminal case. Huh?
She's the.
Moreover, your Ramchandra village is Ashapura Mandali. For less than 10 crores to Manuguru. And Kottagoda, you are asking for Kottagoda for 40 kilometers.
Your Lordship, in Kukatpalli, no one stays.
Yes, you're correct. Yes, sir.
Compromise talks are going on the.
Yes,
This is
sir.
the instruction which is not today in the morning.
Okay. And post for that, I post for orders.
Your Lordship, meanwhile, and stay will be granted for the first. Meanwhile, Your Lordship.
Compromise talks are.
What is the stage of the OP, madam? Then,
Your Lordship, you.
for your satisfaction, I'll pass. I want to dispose as last time itself. Huh?
Meanwhile, stay, Your Lordship. For that, it is, Your Lordship, it may.
You know, Sai Rajan and filed Boka counter. He filed Boka in month of 3rd October, November 2022. Now we are in 6th October, November 2023. 1 year. Huh? So he had both sides. Both after 1 week. Yes, after 1 week, madam. I am passing not after 1 week, madam. He had both sides post for orders after 1 week. Meantime, otherwise I'll pass orders after 1 week. 1 week, madam. Only. We were working with. After 1 week, we'll see, madam.
Item number 48, K. Anup Kumar, K. Devendra.
For the respondent, right?
Morning, someone mentioned.
Yes. And said what happened that the wife approached the sample court. Also CMP. Now, Milad, my instructions are Milad, the parties must compromise. And
Both are doctors.
Both are doctors, Milad, matter is settled. They filed a compromise petition before the court below. That is OP 67 of 2021. The compromise was recorded and the main OP itself is dismissed.
Then give the trial status. Recording of this, close it.
Yes. That is not bad. I took an objection for urgent.
Yes.
I taken OP 67 of 20.
Morning, sir. Okay, they said that only.
No.
Counts for the petitioner, the counts for petition, brother expert. That's why they want time. Already become infected, that's why I will not attend the matter. Counts for response submits. The matter become infected there. The OP filed by the respondent was dismissed as compromise between the parties. Understand? It's also dismissed as purpose. This is done. Date 13/10/2023. Last month. Last year or last month? Last year, 2022.
Item number 49, A. Jagan.
What's the favor of Lord's family? Right? Progress not fair. Very fair. Represent how many offices, sir? No.30's office and, Okay, okay. Constantly. Petition 610, post after 2 weeks.
Item number 50. Yes, Surinder Reddy. Yes, Sharachandra.
I beg to represent my lord on behalf of Sharachandra, my lord, online.
Yes, sir.
My lord, I requesting time, my lord, it's coming for our counter. 2 weeks, my lord, my plan, lastly.
Yes, surrender. Not a. Yes, sir. You have any instruction? The client expired, sir, as per the responsible petitioner.
I'm not aware of it, my lord. I have to get instructions. I'm representing on behalf of Sharachandra.
That's it. Okay. That's right. Okay. That get the certificate and a possible. After 26 time. Post on. Tomorrow. Post on 9. Okay. 8, 11.
Bless.
All expired, sir. Verify with you.
Yes, my lord. I'll get instructions.
Yes, sir. Record it. Record it. Also, press submit, sir. Okay. Okay. What are you want?
Item number 51. Yes, Lalita Prasad.
After post of start discussion. The conversation post after 4 weeks.
Item number 52. K. Kalyani. K. Janaka.
Yes, ma'am.
Petitioner and respondents are wife and husband lordship. The marriage is performed on 14/8/2020. Petitioner filed DBC in pieces of 2021 in Malkazgiri Court. And filed HIGHCOURT 78 of 2021 lordship. Particularly Command Street. Actually, she is dependent lordship. Petitioner is dependent lordship. Her father is retired security contractor. She is very poor people. Every time she is going Sattupalli, it is very difficult. She is having some health issues also, lordship. Financially also she is dependent lordship.
Update also they mentioned that you are residing at Chellapalli.
Yes, lordship, Chellapalli. DBC Malkazgiri Court, lordship. That's where Malkazgiri Court.
Take of the petitioner. The respondents. Post orders after 2 weeks.
Deeply obliged, lordship.
Item number 53. N. Bhaskar. Yes, Anil.
Total both sides. Post after 4 weeks.
Item number 54 and 55. N. Ashok Kumar.
Yes, sir.
Officer was sent, refused to receive. Remove to the server.
Correspondent, who is correspondent number 2? What is it? Petition, sir?
Petition is to, original petitioner died. So when a law petition is filed, it has to be ordered. Transfer is. The daughter-in-law of the petitioner died in an accident. OP was filed for the district court. Father of the daughter-in-law also filed another OP for the same collector court. But after formation of the judicial district, it was transferred to Chadapal. And the petition is filed.
What about husband? What about the son of the petitioner?
Also died and daughter-in-law died and also granddaughter also died.
So both are 78 years of the petitioner now he died.
Oh, he also died.
Now respondent number 1 is 85 years.
Yes. But now petition is filed. Bring the in-laws of the first petitioner as a place of the petitioner. She is only the legal.
Daughter of the first petitioner. So she wants the sister-in-law's about compensation. There's a legal there.
After conducting the trial and all.
Yes, yes, sir.
She will get it.
Father, father also filed petition.
So that's why both the both this was clubbed together and joint trial should be conducted. Because actually he is also filed the same OP in the district court after formation of the judicial district. It was transferred to the Pedapalli. Both the matters were clubbed. Trial is conducted in the calendar minute. That will be beneficial to avoid the contradictory minute.
Otherwise, both matters transferred to Pedapalli. Runners of the father of the decision.
They are not seeking they are seeking to.
No, we can pass modify orders, sir.
We are seeking the transfer.
What two petitions? Why two transfer petitions?
The daughter-in-law's one petition and granddaughter also died in the same accident. But he filed a OP for.
So both grandfathers filed a petition. Vice versa. I have allowed to bring on the petitioner number 2 as this number 1. They are famous. This is related to. Yes, sir. I will take the successful MLT cost rating. Post of the 3 weeks. Both matters.
They are pressing for the trial of the OP. Crossing the meanwhile stay for some extent. For some extent, so that that OP and this OP club together and.
Art case, there is art case services, sir. Now he is also no more. Other also no more now. Yes, sir.
But now they are pressing for the trial and summons was served that was refused to receive.
After 3 weeks, we will pass out.
Short date, only the R movement has to be advanced.
2 weeks, post of 2 weeks. Yes.
We give some dates so that.
28th level, sir.
Item number 56. Vashni.
Yes, madam, Subhashini.
Yes, sir. My lord, the case is being disposed in Sangareddy and the matter been settled and the mutual consent divorce also been ordered. And I pray the honorable court to dispose the case.
The matter of out of court and whether become transfer becoming material attack. They will split and purpose. Excellent. Well, madam.
Thank you.
Item number 57 is Ramshan
No representation, no representation. No consolidation. Post participation after 3 weeks.
Item number 58, R. Bhaskar.
Can you served or not? Sir? Rated? Okay, your OP one, your climate in the OP. So we want transfer from the. Air comfort petition, air comfort petition, post orders after 2 weeks. Yes.
Item number 59, G. Srinivas. Okay. 2,000 petition post after 4 weeks. Honestly, I'm better than that. You want nothing to them. I'm simple them. Item number 60 and 61, yes, Nagesh Reddy, Nikasha, Navande.
They were reserved for judgment and they were reserved for announcement, but on 20th March, they did not reach the list. Fighting did not reach it after the announcement.
Sir, this was on 20th/3/2023, list matters on 11/4/2023, and the caption for conference of orders. 2 months granted to year of same fees extended. I think these are released from the conference of orders. But argue the matter again before me. Yes, sir. Hospital seeks time, post after 3 weeks. Yes, sir, 28 level.
Item number 62, Late income rating.
Yes.
Present transfer petition and seeking transfer from Vidyargada Court to the High Court. Responding before your lordship, they have filed one suit for recovery of possession and mandatory injunction. Present transfer petition before your lordship, he has filed one suit for injunction. Both were pronounced by common judgment at page 12. In that total seconds, one appeal is preferred before the Vidyargada Court, and one appeal is due to the variation has come up before this already. So I'm seeking a transfer of appeals pending before the Vidyargada Court to be transferred and along with the appeal pending.
Appeal filed by the respondents to the High Court.
Yes, ma'am. That is
Case number 17.
yes, ma'am. They have filed OS 206 that has been decreed. Against that, I have filed AS 1754 before this Honorable High Court. I have filed OS 186 that was dismissed. Against that, I have preferred AS 58 of
Okay, both appeals filed by you.
Yes,
Yes,
sir.
sir.
Yes,
Not by the respondent.
no, both appeals have been filed. AS 2 has been decreed, my suit has been dismissed.
Common orders.
Yes, ma'am. Common order.
Then take cost. Very wrongly mentioned cost it. All this very awfully unserved. There is no such person. R4 and 5 unserved. Institutional address. What is the police? Okay. On record in the trial court by Chandrasekhar Reddy was served.
Yes.
On 19/7, he posted the Kazimiti Nekoli. It is 24/7 to the. Personal service. Another response. Most of the 4 weeks. Himalaya is that.
Item number 63, Kalisilana, Legal Niche.
Welcome to CDP. No problem, certified by filed by wife. Filed by wife. Yes, madam, what is the section? I'm seeking time from August onwards. Two weeks, 3 weeks. How much is spending, sir?
Only OT they will.
No. You are filed already 198A.
Only
DVC. MC also pending. All 3 cases pending, madam. Also, not filing counters, where Chandarame. And postal orders. You want file counters, I will pass on that day. Take off the petitioner, postal for 6 times. Postal orders. For after 2 weeks. We need to file counters, otherwise I will pass on that day. There is no limited stage, sir. Continuing.
Item number 64, see correctly.
Yes.
The Wi-Fi is family court license has to get that. The notice is not under this government. I filed the proof of service.
Where was served, sir? Notice was served on?
Notice, USR number 1089.
9/10/2023. Let us address it. Lecture estate, yes.
It has delivered to that 910.
Yes, 9/10. First notice, another respondent. Post after 3 weeks. Next time I will dispose of, sir. We have to give chance, sir. I have to give chance to.
Next week.
Not next week, for 3 weeks. 3 weeks. Okay, 2 weeks.
3 cases that she is suffering
Yes.
without maintenance. 3 cases are pending at Vikarabad. Then ultimately 1 case filed at my.
Okay, post after 2 weeks.
Item number 65, or Madhuri Lata, case Sai Babu.
Guardian, he will be filed in transfer. Guardian, additional family. Guardian of these private additional family. The family court of restitution has been filed. Look at balance. 15th additional.
Now 2 matters pending before the court.
Is it made children?
That document filed by the respondent.
Filed by the petitioner. Guardian of is filed by the petitioner. Family court matter which is a restitution which is being filed by the husband. That is at Kukarpal. Now I am seeking these both mirror nature and the transfer. Kukarpal is posted to the first additional family court to city court where the maintenance is filed. Maintenance mirror the application is being filed which was dismissed by the court. I have partly allowed that has been again sought for the enhancement of maintenance. First additional should direct me to the court below has awarded 2,000 rupees for the maintenance. So the petitioner has filed an enhancement petition to enhance the maintenance.
But the main case is not pending. That's
Main
that.
case is disposed.
Main case disposal. Main case.
Main case is disposed.
Means enough. Dispose. There is no pending case in that. Main case. There is no case pending CDC court. Now we will file a petition for enhancement.
Appeal,
That
they have
appeal.
you have to High Court, that's all, not lower court. Lower court has no power to.
Because we know the lordship is here.
There is no case pending, madam. As per your prayer, you say that MC is pending before the city civil court. There is no case pending. 7 disposed of.
Yes, last time I given your case that is,
Yes.
that MC disposed. MC disposed now.
22/8/2023.
Yes.
August 22nd.
Case is already disposed.
All disposed.
The infractions, this case is, constitutional infractions.
You want husband's case to the Gardner OP case. For the which court?
Civil court.
Medical court, madam. You have filed the Gardner OP at medical court. Deciding now?
Guardian of is filed at nature. That can be transferred to the family court. And the party on that because the maintenance, I need to show this everything that the court below has asked only the maintenance of 2,000. Kindly consider
But
the
they have to be changed here in the concept petition.
I'm seeking both the matters to be transferred to the the part of the prayer that it can be transferred.
Prepare it. Transfer the same to the court of first additional family court at Hyderabad, where the MC is pending. MC is also
MC
pending.
is disposed of. Again, a fresh petition has to be filed.
This file
What is?
This application, Lord.
Find the MP, madam.
Because it is partly, they have filed it. On the lordship may see.
Once the MC is disposed of, if the about the initial change, they have to file an appeal before against the said order, they have to challenge before High Court. They cannot file again a fresh petition in the disposal case for enhancement amount.
Yes, sir.
That is the law.
One minute, sir. No, we love to go to MP, sir. Only now she wanted to transfer the matters to the CDC court. And what courts, madam?
Husband is not allowing the petitioner to see her daughter below with the age of 6 years now. Restitution filed by the husband below she wants only the transfer of the case to the court to trial before the maintenance. And the maintenance is also below which is being considered as difficult. I find that because I couldn't get the order copy of the his partner.
Why you filed before the Mitchell court? You are the resident of Amberpet.
That time we got was of 22 the application. They were separated since 2021 year.
Yes, madam, but you filed a PT before the Mitchell court. You are the resident of the Amberpet.
Maybe she used to stay before the husband's residence, but then she has been shifted to he tried to contact.
Well, Kutubulapur, that's why we filed Mitchell court. Okay. Address of the respondents is Kutubulapur. Actually, it was shown in page number 10. For residential address is Amberpet, but you filed a petition before the Mitchell court.
Was I mentioned that the second respondent is
Yes, page 15.
residing at
Page 15 has seen.
Page
15 has. Filed any counter.
Sir, yes, I am not aware of the prescription by the MP and that no instruction, I get instruction.
the outset of
Because see the new fact, she is submitting that she filed an MP in the disposal matter. Disposal matter, MP,
I'm not taking into account that. I'm not taking into account that. Only there's an hardship of the petition and pass orders, sir. Whether pending at MC or not.
pending so far disposal.
Now she want his petition, her petition to Mitchell to Hyderabad. And moreover,
The prayer she is seeking is where the MC is pending. But
Hold on.
MC is disposed of.
Madam, file amendment of
Let us find amendment petition.
otherwise I will pass order, sir. I will modify the order, sir. I will modify. That's not a technical ground. Her petition she want to transfer from the Mitchell to Hyderabad. She is resident of the admittedly Amberpet. Your petition also clearly mentioned that. I have seen your petition also. Page number 18, filed by the respondent. Also mentioned that she is a Trimal Nagar, Amberpet, Hyderabad. She filed a petition in the Kukatpalli. She filed a petition before the Mitchell court, WP. I transferred both to the CDC report. Then, here cost for petitioner. Okay, 6 times. Post orders after 3 weeks. Meantime, file counters.
Item number 66, and is Arvind Kumar C. Ramchandra Raju.
Yes, sir.
Personal inconvenience. Depends on you.
Any health issues? jet lag. Those are health issues. Sir. Yes, sir. Since long time is coming for admission. Second appeal.
Final.
Post for appeal 6 time. Post after 2 weeks. In the month of election, it is there. Please.
Appealing for appeals, kindly keeping 2 weeks time. Copy of application pending at work, madam.
I think Jarmo sir read the matter. Last time, healthy
Copy of which they have returned, they have no benefits of plaintiff, and again we have filed with the lower appeal and lower high court. They are taking time.
It's long time urgent matter. August onwards. On 14th agent for producing all the last copies of the exhibits. Of course, 6 for the time to produce the documents. Post after 4 weeks finally.
Yes.
Item 68 ended. Item number 69. Yes, Ashok Reddy, D. Jalviswara.
For the apparent against the appeal, argued during reserve consideration for but in fact, there is a really substantial question of law. But
With the other side, sir.
But second appeal.
Sorry, ready or not since he is.
But second appeal is only between the conviction and the court.
But you have to consider already pending since long time, sir.
Consider posted for consideration February, March. Then thereafter, really struggling to get it listed. So when
For me, granting every day for 2 weeks for the listing of the cases. With it. I'm not against your argument.
Yeah, it was posted for consideration. And we thought consistent clarity would be admitting it. But whatever it is, orders may be passed. But unfortunately, it was not been done. And finally, the roster changed. But I'll just take 2 minutes, and your orders may.
Yes.
When they will not apply for the article.
Yes, sir.
But one. She was the owner of the property. She was the owner of the property. He mortgaged the property. Registered mortgage in the year 1989. The Lords may take the document for the entire case on that at page number 70. Is Urdu documents. Recent document. Rashid Unnisa Begum, being the owner of the property, mortgaged in favor of Nacham Bardaya for 2,400 in the year 1959. And page 73 bottom, you'll also find it that she said she'll repay the money within 3 years, where the property will go to the Nacham Bardaya, the mortgagee. Now, for it, unfortunately, neither the mortgagee filed a suit for redemption nor a mortgagee filed a suit for foreclosure. Within a period of 12 years, they have to file. So neither of them filed. Rashid Unnisa Begum died. Her legal heirs have sold the property to the appellant's hearing in the year 1997 under registered section. The registered section. Thereafter, property was booted in the name of the appellants, who were the purchasers. Then the legal heirs of mortgage, some other, filed this suit for declaration to declare that they are owners of the property. To declare owners of the property. The single judge, the trial court judge, the order would find it at page number 40. Page number 40. Issues are at page number 42. Grossman comes to page number 43. Para 11. Para 11. Neither the heirs of mortgages nor the heirs of mortgages filed a suit for redemption or declaration. And since the transaction was registered on, both parties cannot claim the right without exhausting the legal evidence. In the present case, plaintiffs who offer the court claiming dispute relief has to prove the case on their own, and they cannot be expected to take advantage of different witnesses who are not the parties to the mortgage.
So that's how the man of them are filed. We learned the law after many years. Once a mortgage is always one, he cannot become the owner. That's what the principle of debt. But para 18 must page 46. There's a clause on redemption. They can't get clause on redemption. Para 18. The learned judge notices trial court judge. Then the lordship come to page 50. But the trial judge dealt it very properly. Para 26. Admittedly, plaintiffs relying on exhibit A1 by virtue of which they claim to ownership the property was not redeemed by mortgagor. No doubt the plaintiff should become the owner by virtue of exhibit A1, but that should be through due course of law. Plaintiffs cannot become the owner by default in the event of non-filling the condition, but the mortgagor has got two remedies: filing a suit for foreclosure and thereafter sale so that the doors for mortgagor closed for safe redemption. They can file a suit for recovery of loan amount basing on the registered mortgages, but both the remedies has to be exercised within the limitation period. The mortgage has also got another remedy of liquidation which they exercise now, but even that should be within limitation. According to Article 61 of Limitation Act, a suit for redemption of mortgage is filed within 12 years. Article 63 of Limitation Act says a suit for foreclosure has to be filed within 12 years of Indian Limitation Act. The suit for redemption of mortgage is filed within 3 years from take up completion of the conditional period mentioned in the document. According to the Exhibit A1, it was executed on 22/10/1959. Exhibit A1 says the mortgage has to repay the loan within 3 years, and in the event of failure of mortgage, it will be the period of 3 years completed from 21/10/60. The period of limitation for filing the suit for redemption is 12 years from 62. The suit for foreclosure is 30 years from 62, and suit for liquidation 3 years from 62. But absolutely, there is no evidence of record to believe any other legal steps have been taken by national Party or legal arrest. PW himself in his past admitted that no other proceedings initiated other than the present suit. A person who is in commitment cannot permit to claim another position or based on title. Then, National Party was never having absolute interest in property on the date of entering the agreement with the survey. When his position is permissible, we cannot expect to transfer himself to owner of property at the price of non-resident property. Even if the mortgage was at fault, he has to bring a suit for sale of mortgage property to recover his money, and in the absence of the sale, he has got no right to the property except a limited permissive position. According to then your lordship will come to para 29. Para 29, page 52. But in my considered opinion, the context of plaintiff is not sustainable because mortgage will be always having the right of redemption at any condition. Sustaining his redemption would be void even in case of failure of purchase. The maximum once a mortgage, always a mortgage is the principle behind it. A mortgage cannot be made irredeemable in any circumstance. Once a right is created in mortgage, the mortgage can execute his right of redemption unless the mortgage takes steps for sale of property by foreclosure, subject to limitation, and within the time of completion of sale, mortgage is having right to redemption. The position would continue so long as the property is not sold under a final decree of the sale and brought about in the concern. That's how it is done. Third, para 31. When the discussion with respect to validity of the mortgage has come, it is the duty of the plaintiff who has approved the scope of declaration of title and responsibility for the to do the validity and independently without depending on the negative aspects of part of it. As per evidence of available record, it is himself admitted not take any steps by the original owner to foreclose the mortgage, and no steps with regard to declaration are taken by the plaintiff. So finally, the suit has been dismissed in favor of the appellants. Now, first appellate court, we will not come to the judgment of first appellate court. Page 30. And the relevant discussion on this aspect. Para 27, the learned first appellate court did agree with the principle. So, no one can dispute. Para 27, page 25. A mortgage is a security for a debt, and right to redemption continues through mortgage pays to pay the debt at the due date, and any provision inside there is 3 years as fixed in the present case to prevent evasion of redemption is void. It is an incident subsisting with mortgage and substance so long as the mortgage itself subsists and stand extinct as provided under law. Thus, any provision to prevent right of mortgage to given property amounts to clock. That's what a clock in redemption. Then para 38, page 27. The learned again notices the possibility. Evidently, in the present case, neither the mortgager nor mortgagee took any step filing any suit for redemption or foreclosure. Though the mortgagee did not apply for foreclosure, he continued to be in possession of mortgage property and continued to enjoy benefits derived from it without any objection from the mortgagee or children. And the value of benefits definitely exceeds the original amount. So that's what the original amount was paid according to this. Then lordship come to para 34. That's the finding given. In these circumstances, a mortgager is bound to seek delivery of mortgage document, delivery of possession, retransfer to the mortgage property, the cost of mortgage with registered acknowledgement in writing as mentioned in the 60 of Transfer Property Act. However, no such steps have been taken by the mortgagor or the children. But even I have not taken, they have also not taken. Both of them have not done, both of them completely default, a portfolio redemption. In such circumstances, the ownership of property would never be transferred to mortgage. That is the substantive of law.
Yes.
If a mortgagee can become owner of the property because he is only a mortgage, he is only interest. His interest is confined to secured debt. But the burden is wrongly thrown. And then when we logically come to page 30, paragraph 7, last sentence. This is completely not legal. Last, in view of the same, exercising right of redemption is more important than exercising right of, but there is no such balance between them. It's equally, Article 61 and both foreclosure and redemption is okay. If both of them are not paid, whether the mortgagee becomes owner. But page 31, paragraph 40.
Yes.
This is mutation, but in fact, before the mutation, our mutation has happened. So therefore, the first appellate court judge reversed the judgment of the trial court. Well considered trial court. Now, the substantive question of law would be, in the event if the mortgagor doesn't take steps to redeem the property, and also at the same time, mortgagee doesn't take steps to foreclose the mortgage. Whether a mortgagee becomes the owner of the property without any act of the court. Does the law provide that mortgagee by default becomes the owner of the property? That would be a substantive question of law merit. Yes. So this is definitely merit. There is not much law on this aspect. So therefore, this is a fit case merit where when I formulated article certain substantive question of law merit at page 11 of.
Now, receiving rents by the who is receiving rents? What is this second question of rent? The collection of rent, they are now receiving rents.
According to this, they are receiving the rent. In fact, I have taken receiving the rents also. Still, there is a mortgage only. At best, it can be usufructuary mortgage. At best, can be usufructuary, but still there remains a mortgage only without the intervention of the court by court closure. At best, still they continue the mortgage. They never took the owner of the property. That is my substantive question of law number 2, madam. So therefore, madam, this is a case where definitely there is, especially madam, number 5, substitution number 5, has not been dealt by any of the court.
Yes, sir. Fail to seek redemption of student property. That is perfect the title of the.
That's one issue that has not been dealt. Because the principle is mortgage is always a mortgage. By default, they can't, unless there is intervention by the court.
Yes.
So, madam, this is a case where the lordship may consider admitting the second appeal, more so in being a reversal judgment.
You want any remarks in this matter?
Yes.
Then I will hear the.
My friend is here.
Yes, okay.
Because my last time also.
Take some time for giving the HIGHCOURT application. So there is a specific clause in the market.
Show me, what is the clause?
Page 73. This deed starts at page 70.
Yes, sir, 73.
Translation is 73. Last paragraph. It's undertake to make the payment of the mortgage money within a period of 3 years from the date of execution of the mortgage deed. To get the mortgage of the mortgage redeemed. In case of failure to make the payment as agreed upon, that this prescribed period, my redemptions will stand forfeited and the mortgage will be deemed to be a owner. So by operation of law, the mortgage becomes infraction.
You know, they are receiving the rents. Response are receiving the rents.
So therefore, issue number 2, substantive number 2. Now question is, now let us take my friend's argument. There is a clause in the agreement. That was dealt by trial court as this clause in the agreement. Saying that if I don't redeem the property within 3 years, my right to redeem stands forfeited. That's first condition. But can there be a clause in agreement? Can there be an agreement contrary to law? When the act, Limitation Act itself provides for 12 years, or till it is not foreclosed,
of 30 years.
30 years, or 30 years,
or till it is foreclosed, they can't be, unless it's foreclosure, my right will be there to redeem. Any contract to contrary to law is void. That's first. That's what it is. Second is that, and respondent becomes the owner. That's what it says. The clause says respondent. Without operation of law, can by virtue of this document he becomes the owner. That's like a substantive of law.
Declaring the plaintiffs are owners of the plain scheduled property and appellant plaintiffs are relief of the permanent injunction. They maintain status quo, sir. They maintain status quo.
Yes.
Admit the second appeal and maintain status
Regard to the
quo.
admission, I cannot commit to the way.
Yes, sir.
Only with regard to this petition.
Status quo, that is status quo, sir. Maintain status quo till this for this. You're receiving the friends. Receive till this for the second appeal. Here comes the petitioner respondent. Respondents. The following points. So I am taking it to 1, 3, and 5. So the question of law. One.
Let's go only with regard to the possession.
All the specs are, no, all the specs are very clear. Direction clear direction to declare the title of with one of the property and must declare title of the one property.
Because that's one of the arguments saying that I have forfeited my right. I virtue of the document.
Yes. 1, 2, 5, and 6. Let me post the file hearing after 8 weeks. Which is related to call.
Only with regard to alienation.
Not only alienation, but already receiving the rents, sir. Your property, possession property, you receive rents since long time.
Mutation of the issue is there. That's the reason.
Even that's why whoever has got same is letting it.
Declared page number 35. I have seen that. That no related to minus status quo. Page 35 of the. Declaring the plaintiffs are owners of the plain scheduled property and appellant plaintiffs are entitled to release the permanent injunction and exercise the defendants. That's why I'll offer like a last. It is ours. Here comes the petition. Both are related to maintain status quo. This is here today. This was the second appeal. Yes, sir.
Item number 70, Police Vihana D. Jagan Madhav.
Let's call this matter. Against the municipality. Good for? This access municipality working. Conquer training. Okay, appeal also discuss. Counter response 6 10. Already file counter, sir. Post for the 6 and 4 after 3 weeks.
Item number 71, P. Venkatrating G. Srinivas.
Thank you, Pranav. We are seeking time results. Senior is not answered.
A cost of the 6 10. Post after 4 weeks.
Item number 72 to 74, P. Chandrasekhar, P. Ranganatha.
Present P. Secretary. Should we take it?
Next week.
Yes, sir. On this matter?
Please. Responding. Yeah, please, sir. Please,
Okay, Kagate Urban Development Authority. No, it's the month. Yes, sir.
I argued in my just for the sake of Commissioner, it was actually.
Yes, sir.
The plaintiffs had filed a suit. That was against which Kuda filed.
Yes, sir. Kuda set emergency.
That was dismissed. Fully on the ground that two scheduled property is situated in 1250. Yes. The Kuda property is situated in 1235. Yes. But there is a specific report of Commissioner saying that two scheduled property.
Post for the place. And post after 2 weeks. Post for the after 6 10. Post after. Not for order. Second appeal, sir. For 2 weeks. Yes. Yes, sir. Next time I'll be inform them. No mentioning, sir.
List continuation, item number 75, G. Anil Kumar, G. Kiran Kumar.
Your lordship, to serve notice against D1 once again the contested defendant. We have served the notice, we have filed the proof of service. Received by the person.
Yes, sir. Yes, sir. With the plaintiff?
The original plaintiff, it's against a reversal judgment. The original suit was decreed. The lordship passed interim order.
Sir, ready? You're not ready today. Then argue. It's suit for?
Originally, it is suit for declaration. The original suit was filed seeking relief of declaration that the plaintiffs are entitled to 1/3 shares, each from 1 lakh share.
Okay, Samakka Sarakka. You are endowments, you are representing endowments. Where is the endowment department there? Have some notice respondents? Endowments.
We have served.
They are standing on. Okay. I think Deputy Commissioner of Endowments, Team for Endowments has to appear, sir. Why the party?
They are supporting.
Okay, district collector is.
You are not.
He's a party in the suit, but he is also passed.
He became the judge.
Initially, his party in the suit and
He became the
he became the applicant.
Then you have to go to other districts, not by the.
We directed to another corporation. To that extent, it will be done.
Not by Murugu district collector,
Bhopal-
go to Bhopal district collector. Okay. Here also party, collector is
Increase
party, but we have to. Other papers to the, you have some papers to the,
But service only we have
no,
filed.
no. Other papers to the GP for revenue, endowments and revenue, it's better. Second appeal we are disposing.
As per the leading 16, they are supporting our case.
Okay, I'll take it account and pass order, sir. But in the name of the consequence opponent, the counter opponent related to service copies to the G for endowments and will leave for revenue, non-service. Post after 3 weeks. Related to print the name of G for endowments and G for service revenue. Yes, sir. I'll pass 3 weeks. Madam, sir.
Item number 76, Gopal Krishna Kalanidhi, B. Rohit, P. Ajay Kumar.
Yes, sir.
They are fine and we have sent notices and they are delivered on 23rd September.
You are not filed in proof of service? Not filed. How can we take it account, sir? You have to proof of service, sir. First paragraph, 6 type, proof of service, post after 3 weeks.
Item number 73, Kalyan Singh.
The copies of readings. Okay, transfer the front 6 times, post after 2 weeks. The areas are for 2 weeks.
Item number 78, GM Mohan, P. Shravan Kumar.
Both sides. Post after 4 weeks.
Item number 17, KRJ Kumar K. Jagdishwar Reddy.
Ajay Kumar, your case.
No, for the respondent.
No, appellant, cause for appellant. Yes, 79. Huh?
It is coming for counting. They are ready, we are also ready. It is for next week.
What is unnecessary for every case? Second appeal. You are ready? Only here, yes.
Next week.
Look at both sides. Well, I think both of them are ready. Both sides post up 2 weeks. Because both sides post up 2 weeks.
Item number 80, N. Indusina Reddy, K. Mallikarjun.
I am for respondent. Start to solution. Actually, there is a 50 and 71 days delay.
1071 days?
Yes, simply they mentioned 187 days. So they asked for their update for the candidates.
No, order dated
22/2/2019.
19, yes.
2020 they filed appeal.
Excluded in the COVID period up to 1.5 years, 2 years.
So it's more than
Then these days take it like all these things, sir. What is given? Only 187 days.
Yes,
How they calculate 187 days? How the receipt calculate 187 days only?
Anwar and submit this submission to IEC period 2. Next time the affidavit was wrong. So it's good filed by the respondent hearing. But simply saying, can you submit the writing? I submit the petitioner will have filed a suit for position number 103 on the file of principal jurisdiction and share from the grant of permission. That suit was decreed, actually it was dismissed in the lower court. A by statement it is also. Against the judgment that decree, the respondent has filed. Actually, we filed the appeal in the way system. Then it was a decree in my favor. Then they came to you. In the affidavit also not mentioned properly. Which the petitioner here is the defendant and the plaintiff in the suit. I filed appeal. I succeeded in appeal. Then they came to the Sambur court. That to file and 7 for the deletion. Started 28th March 2020.
No, Supreme Court judgment is there, sir.
Okay, it was 2 years.
15/3/2022, 28/2/2022, there is no delay. And we have to suspend the under internship period.
Even they do more the final days.
Then I will ask for the district, who is the student officer? How can you calculate the 187 days? Huh? From February 2019 to take into account up to March 2020,
Yes.
1 year, 365 days.
Yes. That is the 365 days, 1 year is 365 days.
When I obtain the order copy, obtain order copy in okay. Obtain order copy on 1/11/2005 made application on 1/11/2022. Obtain 22/12/2022. That's not the calculation. Yes.
From the beginning of the.
Yes, take it account. Yes.
So before the year.
Huh? File పక్కన పెట్టి తీసుకుంటే వాళ్ళని కౌన్సిలర్ అప్లెంట్ seeks time post after 3 weeks. We should have to print the name of K. Mallikarjun as the constable of the respondent. Doing the same appellant. That's why. All this same appellant law only. K. Mallikarjun as the constable respondent.
Item 81, Jane. Item number 82, first Ravindra Reddy, J. Suresh Babu.
Yes, your case, sir. You are for respondent. Coming for second time.
Yes, sir.
You file a K-weight petition. Ask for time, it is a matter today, 1 week, after 1 week. Reversal, where is it? Okay, for 2 weeks. Post order 2 weeks.
Item number 83, where is Telangana?
Yes.
Respondent, all the document concerned were not filed. First,
Where for the K-weight rule? Well,
yes, Lord. Legal notice which was issued and the same discussed in the judgment.
Rabina Nakka.
Yes, my colleague. May accommodate for day after tomorrow, next week.
Already K-weight is there, sir. K-weight is also put up with Monday. Last second has done the same thing, I think. Of course, that is not a wrong with the possible respondent, sir.
Not denying.
Huh? Last occasion, matter adjourned for the serving of papers to the other side. That's what adjourned 1 week. But then here I was saying that appearing for the respondents. Huh? You argue the matter. When you want to argue the matter, argue. I will hear there then. But they want time now. Yes. Yes, what do you want?
Because their counts of appeal, not they said that not they did not issue the legal notice, whereas the contents in the judgment it clearly says suit for eviction was filed because allowed by the court below.
Okay.
And they did not choose to pay a single rupee from the date of filing of the suit.
Okay, land tenancy matter.
Yes. I'll place those 2 documents before the honorable court so that can be decided as the interim order.
25 20 days. Pay the amount of 40,000 to the vendor of the respondent here.
Vendor is party here. Vendor is party. Vendor is party here.
They filed the petition. I file a comprehensive counter suit. My friend is saying 40,000 paid. His contention before the court below is that he purchased the property from my vendor, whereas he did not choose to file a specific performance. The same contention was recorded in the judgment. He says that not 1,60,000 paid. That was denied, and they did not take any steps. He denies my title itself. So that's the reason that the court below has dismissed both the courts.
Yes.
And they did not choose to pay the rent since from the date of filing. I file a formal counter that the lordship may accommodate.
Conspire respondent. Seeks time. Post after 2 weeks. Which is the end of? Ravina Enna or full name?
Yes.
Full name. Ravina Nakka. Conspire respondent.
We filed the K-weight petition.
Yes, sir.
Please,
Yeah, no,
not
no,
no. Whereas page number
I
5.
saying that other documents, they want to file some documents.
Whatever documents we have filed, we have served.
Yes, sir. There is not a dispute. There is not a dispute here. They want to file some documents. Huh? Yes, sir. After 2 weeks, sir. After 2 weeks. Yes.
Item number 86, yes, Rahul Reddy, from Damodar Reddy.
Yes.
Against page 5. The suit that is filed for specific performance by plaintiff laying upon an unregistered document dated 16/12/2007. The suit for specific performance was filed in 2022. The document seeking for specific performance of an agreement dated 16/12/2007 unregistered document. It is a claim that the husband of the appellant before your lordship
has entered into an agreement of sale, registered, not agreeing to sell land, my lord, for 50 lakhs, out of which 10 lakhs has been paid. But no proof to that effect, my lord, it's all unregistered document, and they themselves not say that it's a receipt and it's an unregistered document. It's not. As on the date, then the husband of the plaintiff, applied before your lordship, died on 3rd April 2010. He is a protected tenant. He does not have a 38E certificate. Until 17th August 2018, 38E certificate is issued in the name of the wife, family members of the person from whom they are claiming as the unregistered document. Again, they come up with saying after 2007, again in 2018, after this they come up saying that they have paid another 10 lakh rupees and they create some receipt. Again, a receipt will not, your lordship may kindly see the receipt also. Just a handwritten receipt, they themselves present and they say they have given. So far 20 lakhs has been accepted. My respectful submission is that the trial court will not initially granted that status code. Thereafter, not after we have filed a counter, bringing it to the fact that notice of the honorable court that under section 30 of this Protected Tenancy Act, there is a bar of alienation act. There is no way an agreement can be enforced against a property and then it's section 30 when there is a bar. They cannot enforce the agreement of sale. So the person will not, as on the date alleged by them, executing that unregistered agreement is in 2007, he does not have protected tenancy. The whole case is revolving around this matter, whether a sale or an agreement of sale executed, more particularly unregistered, can have any bearing on a protected tenant land covered under section 30. There is an explicit bar in the law that no sale can be permitted. And we not have relied on last section or not have given you the agreement. Where is the honorable court said that title will only flow after the 38E certificate is issued. The title comes to me, I cannot execute a sale deed or an agreement of sale or anything. If I don't have a title, I cannot enter into any agreement. The honorable court will not in the other statement and this take your lordship to, he categorically said, until and unless 38E certificate is issued, you are not vested with title. You only have possessory rights, not the title. In the case before your lordship, when they got the status code, we approached the honorable court. We filed the and counter. Your lordship may kindly see the order. Not in dispute, Milord, that the agreement of sale, what they are saying is alleged unregistered document which they are trying to claim. Is of 2007. We are disputing the very existence of the document. It is not in dispute that this person has died in 2010, the husband of the appellant before your lordship. And it is not in dispute, Milord, at that time he did not have a 38E certificate also. Now, my lord, your lordship may kindly see page 8. Page 8 of the letter. Order, my lord. Just read. Paragraph 3. The respondent 1 to 3 filed separate counters denying the material arguments in the petition and putting petitioner to strict proof of the sale. They have denied the transaction of agreement of sale. The lordship may kindly see that. They have denied the transaction of agreement of sale, petition scheduled property in favor of the plaintiff. And so nursing home was and put the plaintiff to strict proof of the sale. They have also denied receipt of sale consideration. And 2 denials. Both these, my lord, registered document they claim, and they also say, my lord, some receipt of handwritten receipt.
Yes.
Both of this is our contentions, my lord, at paragraph 3. They have further pleaded that the agreement of sale itself is a void and unenforceable and contrary to the provisions of section 30 of the Andhra Pradesh Telangana Agency Act, Agricultural Land Act 1950, and section 23 and 24 of the Contract Act 1872. And as such, the petitioner is not entitled for discretionary and equitable relief of specific performances as soon and any relief in the interim of the case. But this is our, that's all our claim. Not just my kindly see. Our case is that it's part by
yes,
how the trial court goes, my lord, the court below.
Lordships may kindly see para 9, page 9, para 7 on this. Whether petitioner is entitled for interim injunction as prayed for. It goes to record all the submissions, it also says unregistered, then your Lordships may see para 9, the same page, page 9. Exhibit P5, the notice dated 1/8/2018 issued by Revenue Divisional Officer calling upon the defendant number 1, that is appellate before your Lordship, to appear before the inquiry on 4/8/2018. Exhibit P6 is the proceedings of the Revenue Divisional Officer dated 17/8/2018 granting certificate of ownership under 38D Andhra Pradesh Act 1950 in favor of the defendant number 1 for an extent of so and so. Exhibit P7 is the Dharni portal extract which reveals the name of the defendant number 1 showing she is the owner of 2/20. Exhibit P8 is the letter dated executed by the sons of Nursing Road. Now here, my lord, this exhibit, my lord, is a self-serving statements among themselves because one person died. So from son, he got an authority to contest on behalf of them also. That's all, my lord. No rights are flowing. Under the agreement of sale, 2-3 parties they have mentioned. One person died, so his son has given authorization to one of the person to contest the matter. That is how, my lord, they are contesting them. Authorizing the plaintiff to continue with the agreement of sale dated 16/12/2007 in his name. Exhibit P9 is the written statement filed by defendant in OS so and so. Exhibit P10 is a certified copy of the plaintiff. Exhibit P11 is a certified copy so and so. Para 11, your lordship's mind. The objection of the respondent defendants is that the agreement of sale which is now sought to be enforced in the suit is a void contract and barred under law. And as such, the suit itself is not maintainable in view of the prohibition.
So how many suits are pending? The parties? Why some 109 to the 22, 113? How many suits? This is suit number, OS number?
Case number
343
of 2022 is there. Between other parties, not between these parties, only one suit.
Okay. Already taken account of it.
These suits are between other parties and the appellant for your. Whereas the plaintiff in this suit and the defendant plus only one suit. At the same party, only one suit.
The Wakala also marking of the document as people.
Yes, yes.
Wakala part of the Kamala.
Yes. I don't know. They wanted to file all the documents, they got their file. That's a different thing. They have to agitate how they want. The question is not whether law prohibits or
yes, sir.
Allows. But someone's wakalat being marked or not may not have any bearing.
Yes, one of the reason for marking the operator can give the answer.
Yes. And 11, the objection of the respondent defendants is that the agreement of sale which is now sought to be enforced in the suit is void contract and barred under law, and as such the suit itself is not maintainable in view of prohibition in the section 30 of the Act 1950 and also under section 23 and 24 of the Indian Contract Act. The validity, legality, and binding nature of the agreement is a question of fact. Right, this is how they go. The validity, legality, and binding nature of the agreement of sale is a question of fact and law to be considered during the course of trial, which will take some considerable length of time for disposal of the suit. If the property is alienated to third parties by the defendant, it will cause serious prejudice to the petitioner plaintiff. But I fail to understand the validity, legality, binding nature of the agreement. The dates are very clear. 2010, 7 they say an agreement of sale has been entered unregistered. 2010, the executant died. As far as they are concerned, the person to whom they claim has died. 38D certificate is issued in 2018.
Yes, sir.
What is there to verify legality, validity? I fail to understand. The dates are so clear. The law is clear that section 30 bars any kind of sale or any, not even these, any kind of transfer will not barred under section 30. I fail to understand how it says it's a question of fact, pure question of law. Facts are not in dispute. The dates are not in dispute. Once dates are not in dispute, so only application of law to the dates. Then your lordship would see that no prejudice would be caused to the respondent defendants if they injected from alienation or alienating the petition schedule property pending disposal of the suit prevent multiplicity. But when the very document itself cannot be enforced under law, that how an injunction can be granted against a true owner.
Not to eliminate, not to eliminate.
Earlier it was status quo. Now, once we showed that it is barred by law, they grant injunction now.
Yes, sir.
I relied on my judgment, my lord, here also we have relied.
2005, 6 ALD.
Yes.
Para number?
Very direct point. Para 50, 51, my lord, and just read 50, 46, my lord. There is a 45 refers to section 30, my lord. Where the bar is there. Another important provision of the Tenancy Act is section 30 for ready reference, section 30 of the tenancy. So that section 30 divisions in a way, subsection 1 of section 30 of the Tenancy Act is an absolute bar for assignment of any kind of land, including sublet, assignment, mortgage, or create any charge or his interest in the land. This aspect has already been dealt with by this court in 1996, 531. Further, 38D of the Tenancy Act deals with the procedure of the landlord. Then, my lord, your lordships may kindly see paragraph 51. As already noticed, the protected tenant would get his right of ownership either by way of notification by the government or under section 38D of the Tenancy Act after obtaining sale certificate from the competent authority upon offer and acceptance of sale and purchase made by the landlord respectively. Paragraph 52. In other words, protected tenant will not get the status of a vendor unless and until he gets right either under section 38D or 38D of the Tenancy Act. In the case, my lord, before your lordships, in the case, my lord, record before your lordships is registered sale deeds. In the judgment, my lord, before your lordships, there is registered sale deeds. Court said no. Here, my lord, they are relying on an unregistered agreement of sale of 2007, trying to enforce in 22.
Yes, sir.
By any means, stretch of imagination, my lord, even declaration suit also is barred by law. 12 years has lapsed long back. They don't specific performance is 3 years. They can't find it. They have nothing, my lord, on that. And section 30 bars them, law bars them, prohibition is there. And there is no facts that are to be decided because the dates are not in dispute. Death of the person, issuance of 38 certificate is not in dispute. Ownership is created on 2018. Law applies squarely, my lord. That's where the honorable single judge has said. In other words, the protected tenant will not get the status of vendor unless and until he gets a right either under 38D or 38D of the Tenancy Act. So if he cannot become a vendor, there is a question of selling. And it's all concocted documents which they have created. But there is no way, my lord, they could have enforced. At least prima facie, my lord, they should be able to establish some semblance of right to have some intention in their favor. There is no right created under law, and there is no right vested under law also, my lord, for them to have any relief being granted in their favor.
Yes.
Therefore, my lord, my respect to submission is, my lord, I am seeking suspension of the injunction, my lord, granted against the true owner by an agreement holder, an alleged agreement holder who is claiming that an agreement which is void.
Yes, sir. Repeating account.
That's all. My submission is concluding. Therefore,
By submission is that only permission has been granted, restraining them from alienating or creating third-party interest in respect of this special property. Then the suit is filed for special performance of the agreement. Can you see the Miller, the main contention of the petition apparent before this court is that Miller, ground number 3. This is the only ground they raised Miller before the trial court and also before the court. The advocate had to have stated the fact that the father of the first apparent's husband was declared as protected tenant in respect of the petition scheduled property, and thereafter the husband of the first apparent succeeded BT right over the petition scheduled land. After demise of the husband of the first apparent, a certificate of ownership under section 38 1950 is issued in favor of the first apparent on 17/8/2018, and the agreement of sale section have been executed on 16/12/2007 by her is much prior to getting a certificate of ownership under section 38 of Tenancy Act 1950, and any agreement entered by the first apparent and her daughter to so and so agreement without right so and so. This is the only contention that as on the date of entering into agreement of sale, he does not have any right to that. Only PT rights are existing in favor of her husband. After death of her husband, the PT rights have been perpetuated by granting 38 certificate, declaring the PT as absolute owner of the property. Any cause of action arises to enforce the agreement. And it's in section 13 of the specific limit act for agreement. Section 13.
Yes, sir.
Rights of the purchaser are lessee against the person with no title or imperfect title. Where a person contracts himself or let such an immovable property having no title or only an imperfect title, the purchaser or lessee has the following rights, namely, if the vendor or lessor has subsequently to the contract acquired any interest in the property, the purchaser or lessee may compel him to make the contract out of such interest. Like the instant case, as on the date of agreement of sale, the husband of the appellant is only protected tenant. Then he got no right to effect the transfer of his rights under section 30 of the Tenancy Act 1950. Subsequently, by virtue of the 38 certificate, by virtue of 38 certificate on the account that the husband was the protected tenant, then wife was granted 38 certificate. Then the petitioner filed a suit for enforcement of that agreement. Since you acquired the title in respect of the property, section 13 says that subsequently the vendor who got no perfect title or imperfect title entered into an agreement. If subsequent to that, if any interest acquired by him, when we can compel him to make the good of the contract. Therefore, under section 30, this is the cause of action for the plaintiff to enforce the agreement. That's why he waited till the 38 certificate granted. He does not transfer any right to the petitioner in pursuit to the agreement. Therefore, under section 13 of the Act, this is the cause of action to file the suit for specific comment based upon agreement 2007 and based upon 38 certificate which has been subsequently granted 2018. That is one of the. Another ground is also under section 43 of the Transfer of Property Act, same provision if any imperfect title holder enter into an agreement and subsequent to the agreement he acquires any interest in the property, he is bound to transfer. The same line is under section 13 of the Basic Act, section 43 of the Transfer of Property Act. Section 43. Transfer by unauthorized person who subsequently acquires interest in the property transferred, where a person fraudulently or erroneously declared that he is the authorized to transfer such an immovable property and proposes to transfer such property for consideration, that the transfer shall, with the option of the transferee, operates on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. In the instant case also, in the year 2018, they acquired the title by virtue of 38 certificate. Then the plaintiff filed the suit for seeking special performance. There is no wrong in it.
Yes.
Therefore, the trial court have rightly observed the consider that way page number my letter friend have read There are 11 objections. The objection of the respondent dependent is that the agreement of sale which is now sought to be enforced in the suit is a wide contract and barred under law, and such the suit itself is not maintainable in view of the prohibition under section 30 of the Andhra Pradesh Tenancy Act 1950 and under section 23 and 24 of Indian Contract Act 1950. The validity, legality, and binding nature of the agreement are seen in a question of fact and law to be considered during the course of the trial, which will take some considerable time for disposal of the suit. If the property is alienated to third party by the defendant, it will cause serious prejudice to the petitioner, leading to multiplicity of the proceedings. No prejudice would be caused to the respondent defendant if they are injected from alienating the suitable land, pending disposal of the suit, to prevent multiplicity of the proceedings and also inconvenience and hardship to the prospective purchaser, as they have been unnecessarily roped into the litigation. Moreover, if the alienation is made by the respondent defendant, it is by the doctrine of expediency under section 52 of Transfer of Property Act 1882. So the respondent do not suffer any hardship or losses if injunction is granted against them. On the other hand, if injunction is not granted, if the respondents are allowed to alienate the property to third party, the petitioner plaintiff is likely to suffer irreparable loss and hardship to himself. Therefore, my submission is that the lower court will not have rightly considered the law and passed the order, injecting them not to alienate the property, pending disposal of the suit.
There is a document filed with amount issued by the defendant number 1 for 10 lakhs. Okay, they did not mention date also.
75 to 77. For your lordship. Agreement of sale. And then this is not at page 78. Page 78.
Okay, Panama also, wife also, there is a agreement of sale.
Agreement of sale.
Now, appellant.
Agreement of sale is in with the family members. 2005. And with the family members.
Yes,
Manamma?
yes, the appellant is Manamma is appellant here.
Appellant here.
2005 2010 I got the 2005 Satyanarayana died. 2007 they say that an agreement has been entered. And 2018 they say registers have been given. And in 2010, my lord, one of the persons, my lord, vendor number 2 died in nursing home. One of the persons who is claiming also died. But my respect to the mission, this 75 specifically has been denied. 42 acres, my lord, for 40 lakhs. For 50 lakhs, they get a document executed like this, my lord, unregistered document. And then the receipt, your lordship may kindly see page 78 and received 5 lakhs in 2000. There is no date, my lord. It says 14th January 2018. 14th January 2008, 5 lakhs. But and then again another one, my lord, at page 80.
16 December.
Yes. No, this installment is forming part of the agreement of sale executed so and so.
You are denying your signatures. You are denying your signatures. Show me your counter.
In my counter, in my things specifically denied. Lordship may kindly see page 22. Page 40, para 10C. Again, my lord, they're everywhere, but again, I'll just take you page 40, para 10C.
I want some counter, sir. Counter to respond number 1. Page number 22. 22, 23, sir. Counter in IA.
All of them have filed the same.
Respond number 1, sir. Respond number 22. Manamma filed the counter.
Yes, yes. 26, your lordship may kindly. 10C. I submit that I once again reiterate the fact that the agreement of sale dated and other receipts filed by the petitioner are never executed by me and other respondents, and no consideration was passed on to us. It is pertinent to note that the documents also said to have been signed by me on behalf of other respondents also are fictitious. The receipts said to have been executed dated so and so and so and so, and also agreement extension document number dated 1/9/2018 also do not bear the signatures of respondent 2 and 3. The lawyers could see those receipts also were not filed. There also may not only one person's signature is there. Rest persons are not signed at all. In 2018, when they say that they have paid 10 lakh rupees.
The third section, the date to issued on in the month 17/2018 to the appellants.
Yes, I'm sorry.
38 certificate. 17/2018.
And the AT certificate is issued on 17th August 2018.
Yes, yes.
Additional page number 25.
Then they
Additional clouds, they raised in the digital statement in the counter. Entire case that not section 30, they came into operation only by virtue of section 30. They don't have any right to alienate the property. That is the stand they have taken. Page number 27, this section 30 has been referred therein and said that under section 30 there is a prohibition.
Yes, sir.
Alienating. Therefore, because these are the tribal issues, not in the trial only, it can be whether validly executed or not. But in so far as legal aspect is concerned, section 30 say have no application upon issuing 38 certificate, the issue owner. Now they are bound to execute the challenge if they executed the application. That is all these are the tribal issues that try to be fair. Therefore, the trial court will not have rightly.
So reversal for the executed agreement in 2007, not by the husband of the first appellant.
I stand corrected. By the date 2007, they have created a document executed by the man. That's exactly what we have denied in our counter also, my lord. That it was never executed. 2007 also, my lord, there was no right or anything invested in the appellant's hands. That only.
What about President Act section 13A?
Yes, my lord. The question is, my lord, once there is a prohibition under a law, can that section come to rescue? There is a prohibition under law. There is a bar under another law, central enactment, and they cannot rely upon contractual rights, my lord, because the contracts will be again subject to.
So read section 13A, read of 1 Read. What is the meaning then?
It says where person contracts to sell or let certain immovable property having title.
No title, having no title. Having no title.
Or only an imperfect title. Purchaser
Or lessee.
Subject to other provisions of this chapter in the following rights.
Following right, 13A.
Or lesser subject to or the contract acquired any interest in the property, the purchaser or lessee may compel
To make it good to.
make good for the contract out of such interest.
Yes, sir. Means rightly filed. 2018 you have 38 E certificate and 2018.
That's 2007.
On that day you are no title, sir. On that day you are no title, 2007.
This document was never existing. That's our whole case was there was no execution of the document.
But title only, it's a title only, sir, not by the others.
The question is, my lord,
Sorry, your production and 2018 only certificate was issued. Wait for all this appeal. Injection not to eliminate the property. Continue position of property.
50 acres of the land, my lord, of the
You continue the property, sir. You continue position of the property. Yes, only. Yes, continue. Only.
An agreement of sale which they are claiming, my lord, is only an agreement of sale. This is the title that.
2018 only you got the title.
Tenant's possession will be from 1950.
Yes, continue.
Title has only come in.
Injection suit present order is not to eliminate property to third party. That is only injection. Granted by the trial court. Pending suit. Continue.
I respect those, but I don't want to repeat it again.
Unnecessary.
Section.
Okay. Post after 4 weeks. Take off a picture of post after 4 weeks. That's a consideration.
Item number 87, Muhammad Ajmal Ali Khan.
Directing the trial court to dispose.
Yes.
Please, Your Lordship.
One minute, sir.
Directly no court will have to expedite the trial of.
Without going to the rest of the case. Yes, sir. Not interpreting the order of this. Yes. Yes, sir.
May it please, Lord. Item number 87, Lordship.
Muted. Wait, sir. Case and within 6 months from the redemption of the sir. Okay.
Item number 87, Muhammad Ajmal Ahmad.
Yes, sir. 87.
May it please, Lordship. Appearing for Muhammad Ajmal Ahmad, Lordship. Counsel for petition in item number 87.
Yes.
Requesting 2 weeks time, Your Lordship.
Demand in their favor.
Yes, Lordship.
Yes.
I'm for responding to Lordship. Nothing is in there. A list of events after dates are required. Let's let both of us will argue the matter.
Okay. Post for the 6 weeks time. Post after 4 weeks.
Much obliged, Lordship.
Item number 88, K. Number.
Yes.
Proof of service, finding your number 061452023. 8:30:10. Proof of services, ID your lordship, registry. Other side are not selling in the same address. So mentioned in the eight copy. And after obtaining the other present address and that address also we find for service user. Same, not staying in that same address.
The suit is pending.
Suit is pending.
Then take notes the cost of for the start in court below.
Counsel for the plaintiff is appealing before the.
Then take note. Some notes are him, sir. That is better.
Sir, I amended that to take a notice. There is no other such order. Okay, I take.
Okay, I will permit this, sir.
Stay is pending, stay is.
Yes, sir. I will extend intimate us, sir. Consultation permitted. Issue possible. Respond as well as concept of response in court below. Post after 4 weeks. Demand and extended till then. So copies to the post after the response.
Number 18, NC Buchiredi KV and Jason.
Yes, sir.
This IA is coming for vacate stay petition. Yes, sir. What is the copy also? Some report was admitted in ACM appeal.
Yes.
Admitted and the 50% was deposited and paid. Now I filed the vacate stay.
IA3, here cost of petitioner respondent. It is permitted to withdraw the amounts deposited by the respondent appellant. I found this code dated 25/7/2023 in IA number 223 in MACMA number 85/2023. The account of MEOP number 225/2017 on the file of water actions plans to come principal district Nagar without furnishing any surety. In case postal pioneering after 8 weeks, neither is covered the court below. Yes.
Item number 93, Buchiredi.
The event correspondence post after 4 weeks.
Item number 91, National Hearing or Tamil
In this matter, please, after an order, case has been transferred to your lordship.
I am for the respondent. I filed an application to set aside the ex parte order. In this matter, I filed the wakalat and also counter. And even after filing counter, and also I was heard by the honorable judge. But subsequently, when the order was pronounced, I was shown as ex parte. So I filed an application to set aside the ex parte order.
My lord's one submission. The order was passed on 2012.
And
1 minute, sir.
Lordship,
Who filed this petition?
petition was filed by the wife for transfer of the case from Secunderabad to Khammam.
Present IA filed by whom, sir?
The present IA is filed by the husband, respondent husband, who filed the OP in Secunderabad.
You are the
family court.
You are the petitioner in IA one. You are the petitioner.
Yes, I am the petitioner in IA. That is pending.
1 minute. I will hear you only IA 1 and 2. What is IA 1? What about, sir? What is this? IA?
IA, actually, I had actually filed my counter also, wakalat and counter. But the honorable court observed that I didn't file my wakalat also despite notice. And an ex parte order of transfer was ordered. And, subsequently, I filed an application to set aside the ex parte order. And His Lordship Justice Samsirao agreed to rehear the matter. In the meantime, there was change of roster and it has come before His Lordship. So I may be given an opportunity of hearing. In fact, there are several Supreme Court judgments because the wife is not working.
Yes, sir. I will hear you. Argue the matter then. Argue the matter, madam. What is your case?
On 2012, the order has been passed, your lordship, but they have submitted the set aside petition on 19/1/23, your lordship.
Which is?
19.
Yes.
The order has been passed on 2012-22, and the case has been transferred on.
Within 1 month, madam. Within 1 month. They filed within 1 month.
But the case has been transferred on 8/3/23, your lordship, and the case is going on in the lower court, your lordship.
What are transferred?
It has been transferred to Khammam, and opponent did not appear at your lordship. I mean, the next date of hearing is on January. They have been sent to reconciliation, your lordship.
So the council want to hear afresh. Ready to argue or not, madam? Argue the matter. Huh? Yes, sir. I will hear you.
Yes, madam. Actually, the OP was filed in Secunderabad for divorce. And the respondent is unemployed. He's unemployed, and I also offered to pay the to and fro charges to come to Hyderabad because the petitioner is involved in construction consultation.
Sir, main case one. She wants time for argument. And post after 2 weeks, sir. Petitioner seeks that post after 2 weeks.
Very well, ma'am.
Item number 92 to 95. Sir, notice.
Yes, sir. Yes, madam.
Due to Monday, he has left some application.
Yes, madam. Argue the matter, madam. Before me, 1, 2, 3, 4, 5, 6. 6 times the matter since August onwards. Sir, June onwards. He's objecting last every time coming a senior, objecting your adjournment. But what is the case, sir, actually? I want to understand the case also. What is case, sir?
This is not, you open the evidence in the case. That's why they found it also. This is evidence they want to do.
To reopen the evidence, second respondent seeking to reopen the evidence. The purpose of marking the certificate of the on to.
This is the only answer.
Yes, sir.
She's asking that.
Yes, sir. Yes, madam. Thursday, next Thursday. Accommodate yourself, madam. It's long time as manager. Once it's a sleep time. Post on 16/11/2023. Yes, sir. Senior Kaushik.
I am appearing in item 96.
Yes, sir. 1994 CCCA, sir. Wait, sir. Senior Kaushik is now online. Wait. Yes, sir.
I am in item number 96, my lord.
Yes, sir. Your case only, sir. What the case, sir?
This is with regard to, in fact, the matter was heard by the learned judge, and we are directed to file written arguments also filed in this. This is a case.
Are you ready or not ready?
I am ready. I am ready.
But
The other side, sir.
AGK system on to time, sir.
Yes, yes. Some time may be given and it may be fixed.
Post for the respondent seeks time. Post after 2 weeks. Sir, 20th level, sir.
20th. All right.
Item number 97, Yellow Papa Reddy B. Nalli Kumar.
Madam, Manjari has gone to respondent side. With appellant side is Papa Reddy. Who is appearing for appellants then? Mistake, sir.
Another has been dismissed for teamwork. Has been dismissed for teamwork. This Lakshman as it was. This is the other appeal. Teamwork.
This might also hear both sides. Reserve for our judgment. January 2023.
So heard something once again reserved.
Release on 30th class. What on madam? This lot of the purpose of workout is there. This matter 1999. The appellants, madam. That's for appellants. Then Manjari has got wrongly printed as respondent here. Post after 6 time. Post after 2 weeks, sir. Post after 1 week. What is the name of? Manjari has gone in place of Papa Reddy calls for apply. 99 still.
Item number 98, Mrs. Galapaj Associates Mohal Mandar, please. Name Mohan.
Item number 98, I am for the appellant lordship. On last occasion, other side have taken time for additional evidence, Lord. Once we receive that additional evidence, senior counsel will appear in this matter, Lordship.
Madam, as per docket order, this matter 7/12/2022, here both sides arguments in IA number 1 of 2022 and CCCA. Judgment reserved. On 30th, they were released from the order. Straight before me.
We have forwarded a mail that they are going to file 40 something. Also sent us a copy of sale date, 1961 sale date. They have
IA one filed by. Yes, madam. Who filed this?
Lord?
From IA one filed by the
Miscellaneous petition IA1 of 2022, my lord. Miscellaneous petition.
23 also filed. Today itself. I think someone filed. 611. His name is there. He was not. Is as party number. Okay. Similarly, Asgar. Proposal client number 2. I think he is not a party, sir. He filed there. Where is petition? Ali Asgar is the okay. The apply number 2.
I am for responding for 3 and 5. So my knowledge is
Applicant number 2. But you are not applying for the applicant number 2.
No.
Person who is coming from Switzerland and representing. That is the person, not Caesar.
Yes. That is, you want up to December. January, in other case, you want also for January.
I have seen him today now in the court. In which case he is appearing.
This case.
Already
Okay. Huh?
This case is already dismissed for default. It's also it's true. And this is the first hearing.
This is for default, sir. The month of December, default, result for judgment. After 10 months, it was released from the 7th call. Get both sides arguments and judgment for the judgment result on 7th call. On 310, sorry, 10. Approve the case, release it from the judgment result. But I am one up to the 22 later. The number like the case is 2 that number like a parliament. Yeah, number of no party person appeal permission. Is there any? No, your client filed a petition as a parting person. So your knowledge. Caesar Ali Sagar. Asgar. Yes, madam.
Yes, Miller.
Your client filed a petition today to receive some documents. Number as a Ayaman, wrongly. First scrutiny this matter.
Yes, Miller.
How can he file?
Kindly have it next week, my lord. Senior will appear in this matter, my lord.
Yes, inform him. You are representing.
On behalf of Bharat Associates, my lord.
Yes, madam. The Wakalat for the Caesar Ali Asgar, but he filed a petition, independently filed a petition before this court. Depends, second depends. Also, can 6 times, post after 2 weeks. You can take number. You can take a party percent less consent.
Obliged, lord.
Yes, ma'am.
Item number 99 suspended. Challa Gundaran G. Ramana.
Yes, ma'am.
Universal investigation.
This one power book. This is I think your client, that's all not fact. That is. Okay. Both factor 8930023. Memo SR number, madam. No.30 memo SR number. 365, 366. Number. Not only today. Another case. Two lakhs per thousand.
Second part is also connected. So these.
Same parties.
Yes, sir, same parties. The first case is statutory farm. The documents that have been marked for conflict. calling from Ganesha here. And in this regard, an insurance policy is obtained in the first plaintiff. The role of the defendant is to transport the oil to its final destination in India once the oil reaches India. The reasons of the plaintiff process of transportation, there was a loss of 9.5 metric tons of oil. The difference stated by the appellant is that the loss has already been set off against the freight charges receivable by the defendant. There are no documents declared to suit against the defendant on the ground that no documents were filed to substantiate the claims of the defendant that loss has been set off.
Okay, capital P not available, madam. What are the comments? We paid capital book and submitted in this street, the same as USR, one USR number. 983, about 6 of 2023, and 9865. They were not provided, it's not the same. They should put up the memo USR number 983, double 2023, and 98365 2023. Most after 2 weeks. Yes, ma'am. After 2 weeks, we leave.
Item 101, Venugopal, Shoshan Chaudhary.
You ask for representing movement. Also, about submission. CCCA number. That one of 2023. The question post matter. Which are the post matter? That one of 2023. 15 level, madam. 15 level. Shankar Chaudhary. Then take personal notice respondents, but you not take personal notice. Once per day. Then I will post up 4 weeks. Once per day. For some extent. Because of him, respondent expired long way. Solution. Also, for the plan permitted to issue notice respondents. And for service post after 4 weeks. Both matters, sir. Okay, this matter I will just for the next. This is a first thing. Corrected the position. This is only gross. Another will see them.
Item number 102, K. Durga Prasad, yes, ma'am.
Yes, sir. Sir, file wakalat. Government how can file wakalat? 2003 matter. India is not a post for dismissal. Why tomorrow? You know, nobody loves any warrant tomorrow. No. Last second they paid wakalat recently, that's why I asked for time. I requested for dismissal. Cash from the dismissal. Comes for the current 6 and post after 2 weeks finally. Meantime, file, cover book and order the man.
Item number 103, K. Banu Prasad, B. Nalini Kumar.
My lords, in this matter, I am appearing for the appellants, my lords, representing K. Banu Prasad. It's a request for 1 week time in this matter. Whether cost survives, I have to inquire.
Yes, ma'am, you have an idea? Cost survives, sir. Money suit.
Money suit, my lords, because the appellant is almost 58 years at the time of filing. But I have to get whether.
8 plus
I have to get.
20,
Suit for Recovery, my lord, partly.
Okay, constable, applies if there is a post after, post after 2 weeks. After 2 weeks, sir.
Yes, my lord, I'm obliged.
Item number 104, K. Srinivasmurthy, Anjali Estanu.
Super. I mean, first time before me. Apparently, Andhra Pradesh, Andhra Cooperative Spinning Mills Limited, Untakal, Andhra madam. Respondent, sir. Corporation of India. This is the follow respond number 2, AP State Federation of Cooperative Spinning Mills Limited. Huh? I think standing council, Srinivasmurthy is no more. Possible appellant, long time. Anantapur. What is the demand of the demand? The demand of the for 2004, it will stay on condition of additional deposit in half of the liquidity amount. Plus interest and costs, if any. What happened thereafter? The first respondent is permitted to withdraw the amount. I will post for dismissal, madam. Necessary pending. Governor come forward to Justice Court. No problem. Post for dismissal after 3 weeks.
Item number 105, C. Raghu. Okay, post for dismissal after 3 weeks. Item number 106, B. Nalini Kumar Rajput.
Yes, madam. What do you want? Ready? Huh? There is no stay, madam. This matter. What is food? Food first. Owner competitive designs. Copyright acts and video rights in respect of 3 movies. Alludu Garu, Sirisirimuvva, Gandhi Nagar, Rendo Vedi. Where Kalanda survives this matter? Okay. First of all, 6 times. Post after 2 weeks.
Item number 107, G. Narasimha, KV Sanjeev Rao.
On both sides. Post for dismissal after 3 weeks.
Item number 108, K. Udayasree, S. Maruti Rao.
On both sides. Post for dismissal after 3 weeks.
Item number 109, YB Ravi Prasad, D. Nalini Kumar. A. Respondent.
What is the matter, madam? Yeah, on the phone. This will performance an agreement dated 1997. 1997. We develop the like. Stay granted by this court, so it's very absolute. Those are applied to court for dismissal after 3 weeks.
Item number 110, D. Krishna, B. Hariharan.
Look at the bad end, man. I'm especially asking. Post for record my single business. Post for dismissal after 3 weeks.
Item number 111, P. Vishwanath Sastry, B. Adhara Rao.
Both sides, post for dismissal after 3 weeks.
Item number 112, K. Chiragdev, Fazil Yusuf, in Basit Wali.
Yes, sir.
Just would respond. Council, do it not let the applicant
This food, sir? Then take no responsibility, sir. Take no. Also, the applicant commissioner. Also, appearing with the respondent. Not the council appearing with the respondent expert. Other council is to practice. Also, permitted to report. After the respondent process, post after 4 weeks. You have a personality. Yes. 4 weeks, sir. Fourth one.
Item number 113, yes, Sri Ganesh, Ravi Pandavati.
Hearing on your. If they got the final report, it also branch to this. Inform, sir. Those who come to apply, post dismissal after 3 weeks.
Item number 114, P. Venkateswamy, B. Balram, N. Sridhar Reddy.
On both sides. Post dismissal. For 4 weeks. After 3 weeks. 3 weeks. Right.
Item 115, G. Mohan Rao, Govardhan Reddy.
Weeks because we
Post after 6 and the section. Post after 2 weeks.
Item number 116, Ms. Rima Sayya.
Welcome to the post dismissal after 3 weeks.
Item number 117, G. Vivekanand.
Post for dismissal for 3 weeks.
Item number 118, N. Papa Reddy.
Most of the submission. Mostly on the product capacity. Extent. Post after 3 weeks. This is the Rema, Manjari has got in place of and Papa Reddy. Post for the plan. 3 weeks.
Item number 119, Sangeeta Jaiswal, C. Prakash Reddy.
On both sides, post for dismissal after 3 weeks.
Item number 120, G. Venkateshwar.
Hello? Consular record. Six steps. Post after 3 weeks. We will prepare Emma. Anjali Esla. Plus of Papa. Next one was same, madam. It was also same.
Item number 122, NVs are Gopal Krishna, Krishnamacharya, J. Prabhakar.
Consular practice. Post for dismissal after 3 weeks.
Item number 123, Reconstruction, G. Praveen Kumar.
What is this case? Hyderabad Trading Corporation. Right. Director Sardar Vallabhbhai Patel National Force Academy.
I'm addressed. Good time to get your business.
Good file for recovery 3,91,000. Civil contracting works and fixing works and interior recovery. Waterproofing and post for dismissal after 3 weeks.
Item number 124, K. Chinchuram, please go and stop.
Lordship, item number 124 and 125 are for the respondent, Lordship. Kindly post after 1 week.
Mothership matter, mothership funds matter.
Yes, sir.
All the consular plans, post for dismissal after 3 weeks, 2 months.
Acha.
Item number 126, D. Madhavra.
Everything been done. Post for apply. Post for dismissal. After 3 weeks.
Item number 127. Governor Shelter Narayan.
No, both sides. Post for dismissal after 2 weeks. 2 weeks.
Item number 128. Fulfill the course, we have.
No, both sides. Post for dismissal after 2 weeks.
Item number 129. NBK Mukesh Vijay Kumar.
No, both sides. Post for dismissal after 2 weeks.
Item number 138. White Sundaresh Reddy, Raja Mahachi.
$75 years in 2004 for apply. $1 itself 75 years. 96 years. People apply post for dismissal after 2 weeks. Both sides. Both sides post for dismissal after 2 weeks.
Item number 131. T. Surya Satish, Village Street Board.
Post for dismissal after 2 weeks.
Item number 132. PQ Magazine.
Yes, sir.
2007 blood, I returned the bundle was taken away. We don't know what is the status of the parties. We don't know what happened.
Okay,
My request is let me go to the door of the registry.
No, sir, no way notice. You have to take it. And dismissal is non-prosecution, sir. You have no. Take into a submissions have dismissal default. Constantly. Appellant submits. They give an objection to the appellant. The year 2007. Now, notice for the prosecutors. For the same. Appeal is dismissal, non-prosecution. Yes, sir.
Item number 133. KV Civilian.
Docket 2005 first, 2004, 18 of 2004. We have successfully expressed by both parties. Matter listed on letter to discharge 6/6/2005. Listed after 19 years, 18/11, 2 years, 6 years. Problem both sides. Post for dismissal after 2 weeks. That you have proceeding as it is. For dismissal. Take up the case.
Item number 134, G. Venugopal Reddy, M. Vijay Reddy.
Milad, it may be taken up on next Monday, Milad.
So what is all this?
May be taken up on Monday.
Yes, sir. What is all this? MPs number of
Yes, MPs are there, Milad. Due to cold and cough, I could not prepare. Next Monday, it may be taken up on Milad.
also the blood 6 and post after 2 weeks.
Next Monday, I am ready, Milad.
Yes, sir. 2 weeks after 2 weeks, sir.
Much obliged.
Yes, sir. For dismissal, report for dismissal, sir. Post for dismissal.
TSHC 246 of 2007.
Okay. Item 133, sir. Okay. No, because first the apply. First the response submit, sir. The matter is connected with the CCCA. Yes, sir. First the response, sir. First the response submit, sir. That is connected with the CCCA.
246 of 2007.
Filed by?
Filed by APS. Filed by respondent.
No.
Respondent at APS. This is filed by the employee APS. This is of same form.
Same order. There was same order, 2 appeals.
Separately. Not under common order.
No, I have this. No, post for dismissal, matter for dismissal, sir.
Because point is same, that is why I did it.
Post is better than also.
It's also same.
Post for 2 weeks. Dismissal after 2 weeks. Yes, sir. It post 2 weeks.
Item number 135, P. Vijay Lakshmi, Muhammad Nasirullah Khan.
On both sides. Post for dismissal. After 2 weeks.
Item number 136, J. Suresh Babu, finance of action.
Yes, Suresh Babu.
Source for declaration was dismissed in the court below. One more connected was CCC 84 of 96. CCC 94 of 86.
86.
Sorry, 96. CCC 84 of 96.
96 Babu.
Connected.
How is connected? 2004 CCCA.
Yes, sir.
96 means?
The
8 years back.
The son, the issue in this case involved is not. A sale deed has been executed by the father of the parties in favor of his brother, and simultaneously, a reconveyance deed also been executed, registered reconveyance deed, stating that the sale deed which has been executed is a mortgage deed and it should be redeemed within 3 years. So the sons, of the sons have filed a suit for declaration to treat that sale deed as a mortgage deed. So and later, sons has filed 84 of 96, and the daughters have filed same suit similarly, which is before your lordship.
That is OS number? Son's OS number?
1485 of 1985.
85. They filed in 1991. So OS number.
Yes. So maybe the issue is same, it can be disposed of because
between the party, both same parties.
Same parties, and the councils are also same. So it can be disposed of commonly also.
Because for the appellant submits this. That is started with the CCCA number?
84 of 96.
84 of 1996. Post this matter also. Post this matter also. After 3 weeks.
Item number 137, N. Sivareddy, K. Anup Kumar, M. Guneshwara.
You are representing whom, sir?
Correct.
Three, right?
Minus Savitrama, ADS of 2004. Absolutely expect. Yes. First one for submission. For number 3. Correct. Use purpose of this for number 3. Give another submission respond. First for the append 610 to bring an LS of respond number 3. Post after 4 weeks. Yes, sir. You have to bring an LS of respond number 3. Huh? Give particulars to the appellant counsel, sir. That is better. They will file petition. Give particulars to the counsel appellant. Then counsel appellant.
Item number 138, G. Sudha.
Hacen los bailes bien, me quedo tratando. Por el both side. Post participation after 2 weeks.
Item number 139, question about KDK.
Only defendant. Court was dismissed on the ground that the plaintiffs have failed to prove the damages caused to the victim. The second is for violation of the conditions of the policy. For not, for the accused driver was not holding the driving license at the time of the accident. These two grounds will not be suit was dismissed.
Injection. What is motor accident they tried to sue?
Yes, if you find not the OP, they escape the court fee and etc. Necessarily they have chosen civil court.
TSHC engineering and contractors, sir.
Yes. He was the plaintiff now. He died. So his son was brought as
yes, sir. Post the appearance. Post after 1 2 weeks for dismissal. For dismissal.
Item number 140, T. S. Venkatramana, D. Sudeshan Reddy.
Yes, sir. Standing counsel, central government. Your case. Union of India. General South Central Railways. Yes, Venkatramana. Huh? You have no question. Hold on. Item number 140. This is the name of Gari Kumar. Then President of India. In place of T.S. Venkatramana, Consular appellate. Post after 3 weeks.
Item number 141, SSNC Singaraj College.
Number of appellants post for dismissal after 2 weeks.
Item number 142, P. Pratap Reddy, M. Srinivasa, B. Tulsi Reddy, B. Blessing Stamma.
This fruitful. They was dismissed. I am one of the protected. Records for petitioner. Other records. Petition file to. Then petitioner 224 from petitioner 224 and regular something. So appellate. First appellate or post appellate? So appellate. Record. Issue letter to. Because it is to another task. Hello. Please state the pillar name of Ashok Reddy, Karatala, impressor, P. Pratap Reddy, post for the appellate, post after 3 weeks. Sir, I don't only final hearing only, sir. So then 4 matter, only final hearing only. After that, left state.
Item number 143 and 144, Pawan Kumar.
Of 7/12 of 2004, going to model. About this company. No consumer petitioner. Post on apply. Post petition after 2 weeks. But also like other little bit.
Item number 144, please. Pawan.
Okay, same parts 2 weeks. Yeah. No problem.
Item number 145, L. Sudhir, I. Ramesh.
What the respondent?
The suit for
Partition.
out of, okay.
Narayan and Nandabai died. Guys, Nabai. So I think it's what.
Respond number 4, the time of filing of appeal 740 years, 70 years. Yeah. 70 is 1997.
He also died, my lord. But the respondent also died.
Council appellate submits that. Appellate number 1, 2, 3, expired. And also the respond number 4. Also, some of the respondents, not the respondent. Also, not the
Sure about that.
Right, that's why some of the respondents, right? He sent by the public petitions. Post after 4 weeks. Yes, sir. No mentioning, sir. 4:30.